Unit 9 to this point. Yeah. Is it, did I see Joy? Where is she? Hang on, I'm moving you guys around. I'm shifting you around. Let me find you again. Get set up here. There she is. Joy, did you have a question? Did I see you? No?
No, I'm okay.
Okay, good. Good, of course. I thought I saw a hand, so I just wanted to be, I'm always on alert, you know, so you make a movement and I'm like, what? All right, so again, you guys, please hear me. The key to Unit 9, the trick to Unit 9 is the vocabulary words, understanding what those words mean. Because like I said the other day, we're not attorneys, we're not in law school. I certainly don't want to give you guys the impression that I'm giving you some kind of power to run around and practice law. The real estate license does not allow us to do that. However, because we work with contracts on the regular, I mean, we work with contracts on a daily basis between our sales contracts and our agency agreements. So we need to understand how they work, the ins and outs of a contract. And that's what we're doing in Unit 9. So knowing those words, knowing those key terms. And we're going to start back up right where we left off, page 261. And what you see on 261 are some general rules for interpretation of contract. These rules for interpretation of contract is how the judge is going to see it. What is the judge going to look at when and if they get this contract in their hand? The one thing mentioned on 261 that we've already discussed was the parole evidence rule. The parole evidence rule says the final written word will prevail any other previous negotiations. So if we agree to something and it doesn't make it into the final contract, the parole evidence rule says it doesn't count. The judge is not going to interpret it that. Some other general rules, the judge is going to interpret the contract as a whole. So they're not going to piecemeal it. They're not going to say, you know, a lot of times with our contracts, it's not uncommon. We have at least one addendum. We have at least one seller disclosure. So when we're submitting and negotiating offers and going back and forth, we're not just dealing with an offer to purchase and contract. We're dealing with applicable disclosures and addenda. And the judge is going to interpret all of that as a whole. They're not going to piecemeal it and say, well, this applies, but this doesn't. It's all in one. The words in the contract are going to be interpreted per their ordinary meaning. You guys have figured out by now, us brokers, we got our own language, don't we? You're going to start speaking broker and using our jargon, and you'll find yourself talking in acronyms because that's what we do for anything that we can. Guys, our jargon, our verbiage, our speak does not belong in their offer to purchase and contract. So when we are filling in the blanks on behalf of our buyers or sellers, we need to make sure that we're using words and terms that the general public understands. So we need to make sure that our words are not ambiguous, ambiguous meaning unclear or uncertain. The parties to the contract should be able to pick that thing up and understand the terms that we're filling in for them. So our verbiage doesn't belong. As we mentioned the other day, when we introduced you to a contract, any legally binding contract is going to have what happens if one party breaches. Remember, the contracts are typically bilateral contracts. Bilateral means how many sides have to perform. You can show me how many sides have to perform. Yeah, bilateral means two sides, both sides have to perform. So if our offer to purchase and contract is a bilateral contract, that means the seller has duties and obligations they have to perform. And the buyer also has duties and obligations they have to perform. And if either party doesn't do what they promised to do in the contract, then they're considered in breach. Now the question is, what happens if somebody breaches? And that's what has to be spelled out in our contract. In basic contract law, we have the conversation, we talk about contract remedies. Again, basic remedies, understanding each contract has its own specific remedies. What happens if they breach? So basic contract remedies, a couple different things. The first set of remedies that we're looking at here are money damages. Somebody's going after somebody for money. And there's three different types of money damages that we may see as a contract remedy for breach. Good morning. The first is compensatory damages. Compensatory damages are meant to make the injured party whole. I spent money on this transaction, you breached, I want to be reimbursed. I'm not going after you for anything above and beyond what I spent as a result of this transaction. So for compensatory damages, with our sales contract, typically what we're going to see is in the event of the seller's breach, make sure I say that right. If the seller breaches, for example, the buyer could go after the seller for the money that they spent on inspections, the appraisal, any fees or deposits. Did they have a survey done? Any money that they have spent so far in relation to this transaction, seller breaches, buyer can go after them for compensatory damages. The contract does say that the seller will reimburse for compensatory damages, but if the seller isn't willing to sit down and write a check, then the buyer may have to take them to court. Let me come back to liquidated in just one second. Consequential damages, again, are also money damages. These are special damages. These are things that somebody, they happened. We couldn't really foresee them, but it still happened. Maybe somebody breached the contract and now I got to pay attorney's fees because you breached. I didn't foresee that. I couldn't tell, but now we're here, so we got to deal with it. The consequential damages are special damages. These are kind of going after, think of the pain and suffering. We're going to see, when we look at our contract in Unit 10, we're going to see maybe another good example of consequential damages. We're going to see that the buyer is responsible for anybody that they hire to perform an inspection or investigation. So for example, if the buyer's home inspector damages the property, the contract says that the buyer is on the hook for that because the buyer hired that home inspector. That would be an example of consequential damages. Let's go back to liquidated damages. Liquidated damages are also money damages, but they're a little bit different. Liquidated damages are money damages that we agree to upfront at contract formation. So we agree upfront, if I breach, I'm going to give you X amount for my breach. So we set an amount, we negotiate it, we counter it, and we come to terms on a set amount. If I breach, this is how much I owe you. Those are liquidated damages. In our sales contract, liquidated damages are awarded to the seller in the event of the buyer's breach. So we'll see that when we look at our sales contract. Liquidated damages are awarded to the seller in the event of the buyer's breach. Yes, ma'am.
So are you saying that with, look, I can't even pronounce it, compensatory
Compensatory, compensatory.
damages, that's specifically for the seller reimbursing the buyer?
That was just an example. So
Okay.
anybody could go after that for money. So if the seller spent money on the transaction and the buyer breached, they could possibly go after. Yeah. So that was just
Okay.
the more common example is going to be the buyer going after the seller.
Gotcha. But with the liquidated, was that also just an example? Or is that it is.
No,
the-
that is,
Okay.
yep. The liquidated damages is the seller's remedy. And that is actually spelled out for us. It
Okay.
tells us in the contract that this is the seller's, this is pretty much what they get.
Sounds good.
Unless, something unforeseen or, the what ifs, right?
Gotcha.
So our money damages. Again, you guys, if somebody's not willing to sit down and write a check, then the injured party will have to take the breaching party to court. Attorney's fees, and our contract addresses that if we do have to go to court. So we'll see that again when we get to Unit 10. There are other contract remedies, though, that may not be specific to money. Another contract remedy is called specific performance. With specific performance, the injured party is taking the breaching party to court, and if the injured party wins, the judge can make the breaching party perform as promised. What did they promise in the contract? Now I'm in breach, the judge could make me perform. The example where we see this in our sales contract, in the event of seller breach, the buyer has the option to go after the seller to make them perform. The seller's number one obligation in the offer to purchase and contract is to sell. So the buyer could go after the seller to make them sell, to make them continue as they promised. I can't make the seller do that. That's going to be something of the judge. So yes, we have to go to court. I shy away from words like never. So I'm not going to use that right now because I don't know all the court cases out there, but I'm going to say it's going to be really, 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 really rare for a seller to take a buyer to court for specific performance. I'm not going to tell you it's never ever happened, but I'm going to tell you right now where we see it the majority of the time is the buyer going after the seller for specific performance. The other contract remedy, or another contract remedy, is a rescission, to rescind your contract. If you're rescinding your contract, you're taking it back. If you put down any deposits and you rescind your contract, you'll get your money back. When you rescind your contract, both parties are put back in the position that they were in before they went under contract. It's almost like that contract never happened. It just poof, disappears. And everybody's put back in the same position they were in, and both parties go about their lives as if this contract never happened. Why don't you guys set, I got some questions for you guys. Good morning. Why don't you set your chats to private? Just chat just to me. Everybody ready for me? How many days does a buyer have to rescind their contract for a timeshare? How many days does the buyer have to rescind their contract with a timeshare? What do we remember about timeshares? 5, 5, 5, 10. All right, so we narrowed it down to 2, right? How many days do they have to rescind? They have 5. In a timeshare, the buyer has 5 days to rescind their contract. Meaning, yeah, that's what I meant. Yeah, meaning we go under contract. We go under contract. The buyer has time to look at it. The buyer has time to contact their attorney. The 10 is how long the developer has to keep the trust account, the money, the deposit in the trust account. Unit 2, review unit 2. All right, another question for you guys. How many days does the buyer have to rescind their contract in a new construction condominium? How many days does the buyer have to rescind their contract? Again, unit 2, and a new construction condominium. And that one is 7 days. 7 days to rescind. We go under contract. It gives me time to look at it. Do I want my attorney to review it? If I change my mind, I take my contract back, I get my deposits back, and both the builder and I go about our lives as if this never happened. So a couple examples there that we've already hit on some few things. Another thing, just again with terminology, not so much with specific remedies, but just with the terminology, and this isn't specific to real estate, you guys. Any lawsuit, any court case has what's referred to as a statute of limitations. This is just how long you have to bring action on somebody. This is how long you have to sue somebody. In each case, each situation is going to be a different statute of limitations. It's going to be a different length of time. So how long, I guess the advice here is if you think you're going to sue somebody, you better do it sooner rather than later. Because once that statute of limitations runs out, you've lost your right to sue. Call your attorney. CYA. All right. So with all these forms and all these legal terms and everything that we talked about in this unit, I really feel like we're giving you guys just enough information to make you dangerous. So let's break this down and let's talk about what this means specifically for us, the brokers. I cannot practice law, you guys. We're not in law school. Is anybody an attorney? I'm just curious, actually. No, I've never had an attorney in free licensing. One day. I cannot wait. So we are not attorneys. We cannot practice law. And specifically when it comes to our forms, I cannot draft legally binding documents. I cannot draft legally binding verbiage. I cannot draft because I am not an attorney. I'm just a real estate agent. What I am allowed to do specific with the forms is fill in the blanks. We saw some blanks in our agency agreements. I'm allowed to fill those blanks in. We will see some blanks in our sales contract. I'm allowed to fill those blanks in. I cannot add or delete provisions because the parties want me to. Now understand this. The parties to the contract can draft and add and delete. When we're talking about our sales contract, who are the parties to the contract? The buyer and the seller. They can pick up their pen and add and delete and remove. But just because they can, doesn't mean that they should. When your party picks up their red pen and says, I'm going to fix this, we need to advise them to talk to their attorney because they don't understand, and I don't understand the legal ramifications, the legal consequences of making that addition or deletion. So just because they can does not mean that they should. Your parties are going to ask you. I get calls on the regular from my agents in my office. My buyer told me to add this. Well, we want to be obedient, don't we? We want to follow our clients. Remember that word in parentheses, lawful instructions. And they're going to ask you guys, because I'm a heck of a lot cheaper than an attorney. So they're going to ask me, can't you just change this? Can't you just add that? It's not their job to know the parameters of my job. That's my job to know the parameters of my job. Everybody with me? So we need to be prepared to how to respond when they do ask. Question comes in, ask me if I'm a BIC. Nah. I'm just very involved with my firm. I've been around. We've been together for a long time. We got to do I did our sales meeting yesterday. You know, we talked about these forms changes. So we did our sales meeting yesterday. We spent a whole hour plus just talking about forms. Doesn't that sound like fun? That's all right. We had tacos brought in for lunch, so that that made it worth it. I will do anything. Well, what would you do for a taco? What would you do for a Klondike bar? Yeah, there you go. All right. So the other thing to understand, because everything's in writing, eventually, if we do make any changes, those changes need to be in writing. So all of our changes or additions dated, initialed after the fact by all parties. Kind of the last piece, I think I got two more short pieces in Unit 9. This is our other slide on auction sales. Remember, we're treating auction sales completely different from any other type of sales, residential or construction. Auction sales belong in their own bucket, their own category, all by themselves. And remember, we're not worrying about auction sales on our test unless the question specifically says something about an auction sale. So is everybody good with me on that? They don't exist unless the question tells you that they do. So just real quick with real estate auctions specifically, there's two types of auctions, those with reserve and without. An auction with reserve says that the seller has the right to stop the bidding at any time if they're not satisfied with how it's going. So if they're not pleased, if the bid's not enough for them, they can say, stop, 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 we're not doing this. An auction then without reserve means they can't stop the bidding. They get what they get. Another thing that makes auction sales so unique is that the auctioneer has the power to bind the seller. So when that gavel comes down and the auctioneer says sold, congratulations, we're under contract. Obviously, the next step would be to put that in writing. But when the auctioneer says sold, they have bound the seller and we are under contract. An auctioneer will have a real estate license because they're going to represent the seller in the transaction. An auctioneer will also have an auctioneer's license. So they have two separate, which again makes them a little bit different. And then the other thing I want to do, I got to go off book for a second, kind of, sort of. There's another word that we need to define, and I feel like Unit 9 is the best place to define it. It is actually in Unit 10, but it's like buried in other material, and I always have a hard time finding it. So I just throw it in Unit 9 to make sure that we cover it. And then the other word when it comes to contracts that we need to understand is a contingency or something that is contingent. If there's a contingency in a contract, basically what a contingency says is, I'm not contractually obligated to do my part if something doesn't happen first. So something has to happen in order to make me contractually obligated to perform. In real estate, some examples of where we may come across a contingency may say, I cannot buy your house if I don't get the loan. So I'm not contractually obligated to buy your house if I don't get loan approval. Me buying your home is contingent on me getting loan approval. Another example of a contingency, I cannot buy your house if I don't first sell mine, which means I'm not contractually obligated to buy yours until I sell mine. This is what we need to understand about contingencies. Our sales contract currently has no contingencies in it. Let me ask you guys a question. Can the parties agree to add a contingency? And the answer is yes. So we don't have any built in, but we need to be aware of them, because what if the parties agree to add them? This second one specifically, you guys, we've not seen much lately because we're in this crazy seller's market, multiple offers and everything. Think about it. You're selling your house, you got 30 offers in your hand, and one of them includes a contingency. You're going to take that one, you're going to look at the other 29, right? So contingencies, we've not been seeing much of these lately. But as that pendulum swings back and we start getting into a buyer's market, we may start seeing contingencies pop up again. The other thing about contingencies is we don't have any pre-printed forms for contingencies. We used to have one and they retired it. So if your parties want to add a contingency, if it's, we got a couple sentences we can, kind of fill in if it's basic, but if it gets complicated or more involved, what do you think we're going to tell our parties to do? CYA. Call your attorney. I see several. I just recently learned that not everybody knows what this means anymore. So for those of you that don't, I know, right? So for those of you that don't, this means we're calling somebody. This is what we used to have to do. I think maybe I need to start changing it to that, or like that. That's what I. So continue, and these are just a couple examples. Yeah, we could add a contingency for anything that the parties agree to. Does contingent and pending go hand in hand? No, they're two different things. Pending meaning it's under contract. Contingency meaning something has to happen, something has to perform. Yeah, George.
So, quick question. So when you go online on like Zillow, Realty.com, you see a lot of those homes that have this that are contingent. So
that might be, and Vaughn, that may take me back to your question. That might have been what you were just asking too. That might just be the terminology that Zillow uses, saying that it's contingent on the close. So to help you pass this class, please log off of Zillow. So because that just might be how they use that word. I'm not saying it's right or wrong, but I'm saying for our purposes, understanding for contract law, that contingency says before this happens, then that has to happen.
Okay, thank you.
Sure. Let's see. So you want to buy a home? Would your realtor put a bid on the house with a contingency if you haven't gotten a loan yet, but want to put in a bid? No, because we're going to get pre-approval. All of our buyers are going to get pre-approval, and then they'll get final. Nobody gets final loan approval until we're under contract. So no loans are a guarantee, right? All we have is a pre-approval. We don't get that final approval until we're closer to closing. So we'll talk more about that process. Now, the parties, again, could add a contingency, and then they'd have to have something drafted up.
Okay, one quick question, please.
Yeah.
Okay, when I was trying to buy my home, the realtor I was working with, she was showing me houses. I went and signed a contract for a home. Then the next day, I went to take a second look at the house, and I was like, okay, this is not what I like. And I wanted to cancel the contract. So she told me, let's look for another home that is being sold by the same firm, and see if we can get it, if we can transfer that contract to the other home. So I went and looked at the other home. It wasn't what I liked. And I told her, okay, I'm not getting to this contract. She was like, okay, if you keep refusing homes, you might get flagged something for maybe, refusing contracts that you've already signed and all of that. I was like, okay, if I don't like it, am I forced to even if I sign a contract and I come to site to 2 days that I don't want it, am I obligated?
So,
By-
so there's a lot of it depends in there, and this is a very specific personal, but if I can just try to answer like real quick. In general, depending on what contract you use, it would spell out if you had the option to cancel, to terminate the contract, and what, if any, consequences to that canceling and termination you may suffer. When we get into our contract, we're going to see the buyer has an out. Specifically to our contract, the buyer does have an out. Now, if you were using another contract, your out may look a little bit different. So without seeing that, the other piece of it about being flagged, I'm not familiar with that. I don't know about that. But yes, in our standard contract, when we get to unit 10, we're going to see the buyer has an out. So if the buyer wakes up tomorrow and says, nah, I don't want to buy, they can terminate. And we're getting to that in unit 10. Yep. Another questions comes in, what is the difference between contingency and a bilateral contract? Remember, bilateral, unilateral, we're just referring to sides, how many sides have to perform. So contingency says this is dependent on something else. Bilateral and unilateral. Unilateral says one side has to perform. Bilateral says 2 sides. So that's kind of the big picture of the contract if we choose to add a contingency. So they're two different things there. And that gets us through unit 9. Again, you guys, I cannot stress those key terms back on page 253. Key point review on 264, good checklist. I know what this is. I know what that's talking about. I don't know that. Let's go back and look it up. And then you have your student quiz, page 266.
Julie?
Yeah.
If you sign a contract and you had to put down due diligence and earnest money, what is the difference and what would you get back if you canceled the contract?
Bear with me, Nicole. We're going to talk all about earnest money and due diligence in unit 10. Yep. How that works, what it means. Yep. That's back to our buyer's right to terminate. Anything else on unit 9? Basic. Unit 9's our basic contract. How does a contract work? All right, now we're going to get in. Let's bring real estate back into it. Unit 10 is specific about our sales contract, our offer to purchase and contracts, and different sales practices. So in unit 10, our map for unit 10, we're going to talk about our standard offer to purchase and contract, the one that we use the most often. We're going to explain some sales contract procedures. And then at the end of unit 10, we're going to talk about some alternative methods for conveying land. Not everything happens with the traditional offer to purchase and contract. So there's some other options and alternatives, and we'll see those at the end of unit 10. So, as mentioned, the most commonly used sales contract by realtors in North Carolina is the offer to purchase and contract standard form 2T. You do not need to know the 2T. Our forms come from the North Carolina Association of Realtors. That's what NCAR means. North Carolina Association of Realtors. NCAR is the state level of the National Association of Realtors. So you got the National Association of Realtors, you have the state level, and then you also have your local level. For example, Winston-Salem Board of Realtors, High Point Board of Realtors, Charlotte Board of Realtors, etc. So our Board of Realtor membership is 3-tiered, and they all do 3 different things. You'll learn all about that when you're ready to affiliate with a firm. That's not tested, thus, we're not talking about it here. So NCAR provides our forms. I need you guys to understand this. This is a problem topic. Brokers and realtors can use other sales contracts. Just because we have 2T, all we're saying is that's the most commonly used one. But we can use other sales contracts as long as they were drafted by an attorney. It's not uncommon, for example, for a builder to have their own sales contract. It's not 2T, but we can use it. Specifically, Commission Rule A.0112, which is just there for reference. A.0112 says if a broker is using a non-NCAR contract, there are certain things that must be in the contract. And that's what A.0112 addresses. Again, you guys don't need to get into those specific things yet. You'll talk more about that when you get to post licensing. What you need to know today, NCAR forms aren't the only ones that we're allowed to use. They provide them just to make it reduces our temptation to draft. Not all states have pre-printed forms, by the way. Some states may use what's referred to as a letter of intent, meaning I'm going to send you a letter about what I intend to do. And once we agree to that, then we go to an attorney and have them draft up the final document. They provide us with forms to use, which makes our lives, I feel like, a little bit easier.
Julie?
Yeah.
If they don't have the pre-printed form and they're using their own form, under your infinite wisdom, will they have it like a approved form or something like that stamped on it or written on
Usually
there or
I
something?
see drafted by big, long legal law firm name, you know, so
Okay.
usually I'll see something like that. Yeah. If
Okay.
not, my little red flag just went up for me to pick up the phone and ask some questions.
Okay.
Yep. Just reference a couple commission rules. Again, A.0112 tells us if we're using a non-NCAR form, this is what must be there. A.0111 is a commission rule that says brokers, real estate agents are prohibited from drafting these documents. So again, you don't need to know these numbers. I'm just referencing the rules and the laws. We just said a few minutes ago that our sales contract is between two parties. Who are the parties to the sales contract? They are the buyer and the seller. Did I just say the real estate agent? Yeah, no. So when it comes to our sales contracts, we do not belong. We are not a party to the contract. Specifically, in the sales contract, we cannot have any mention of my compensation, bonuses, referral fees. My money does not belong in the sales contract. Where does my money belong? Where do I discuss my money? Where do we hash out how much am I going to get paid? I see mouths move. That belongs in our agency agreements. Would it surprise you guys if I told you there have been cases reported down to the commission where agents try to slip themselves in a $5,000 bonus in the sales contract? They sign it, and now the agent thinks that they're entitled to that. How far do you think that's going to make it in a court of law? Yeah, no. What do you think the real estate commission is going to feel about that? Yeah, no. So we do not belong in the sales contract. Everybody hearing me? The other specific thing is that we can't add any kind of liability disclaimer in the contract. So for example, if my buyer chooses not to have a home inspection, I don't know why, maybe they're cheap and they think they're going to save some money. And they say, no, I'm not going to have a home inspection. I cannot try to put that in the contract to protect myself. We actually have another form that we can use between us and our clients of whether or not they're going to select or waive different services. So if they're waiving the home inspection, they provide us a form to keep it out of the contract, because getting a home inspection is not a contractual obligation between the buyer and the seller. So again, the big picture, we don't belong in the contracts. These are between the parties, the buyers and the sellers. One thing that's gained popularity quickly in real estate across many, many industries is the usage of e-documents and e-signatures. And we have an act that pertains to using e-documents and e-signatures in sales contracts. It's the Uniform Electronic Transactions Act, or the UETA. We also have a state level of this, referred to as the North Carolina Uniform Electronic Transactions Act, or the NCUETA. They both run hand in hand. The UETA addresses electronic commerce, and this does include real estate transactions. And one of the big things that the UETA says is, once you agree to allow an e-signature, that e-signature is binding and it counts as your legally binding signature. You guys all signed something for Lane to be here in this class. If you didn't, please do so. She'll have to hunt you down. So you guys signed a contract for Lane, yes? She sent you an email, or I guess you received it. And you clicked on the link to sign the contract, and a little box popped up for you to adopt your signature. But before you adopted your signature, you clicked on the terms in use, and you carefully read those to make sure you knew what you were agreeing to before you used your e-signature. Yes? What? Huh? You didn't? Do we ever click on that terms and use? And if we do, we're like, my God, this thing is 126 pages. Who has time to sit here and read this? Had we read that terms and use, part of what you're agreeing to when you adopt your signature, you're saying this counts as my legally binding signature. And having that in the terms and use, having you agree to that, whether you read it or not, comes from the UETA, making sure that they at least put it out there, that they tell you that your e-signature. So in other words, does anybody's e-signature look like your actual handwritten signature? Anybody? Nobody, right? So in other words, you can't show up to court later and say, this isn't actually my signature, you agreed to it. We'll talk a little bit more about electronic communication in just a second. But first, let's go back, starting on page 284 over to page 285. We have a really nice review of our offer and acceptance. So we introduce you to the parties in the offer or and the offeree. The offeror is who? The offeror, don't you say buyer. The offeror is the giver of the offer, the person making the offer, the creator of the offer, if that helps. And the offeror is going to give an offer, make an offer to the offeree. Who's the offeree? The person receiving it, the receivee of the offer. I don't believe I saw Mal's move that said buyer or seller, so good job. Giver and receivee. So an offer is made, and the offeree has always three choices. What were those three choices? They can accept the offer, they can reject the offer, or they can counter the offer. Whenever an offer is made, an offeree always has three choices. So let's go back to our, I need a better name, contract communication wall. Maybe I'll start a contest for a better name. Okay, so our contract communication wall. Buyer's on one side, and most of the time, the buyer's going to be the one making the first offer to the seller. So in this example, we're going to have the buyer as the offeror on one side of the wall, the seller as the offeree on the other side of the wall. Buyer makes an offer to the seller. Seller has three choices. They can accept it, meaning they agree to all of the terms exactly how they are. The seller can reject it. The offeree can reject it, meaning they've killed it. The offer is dead on the table. There is no reviving a rejection. There is no going back. So let's say, for example, I'm the buyer, you're the seller. I make you an offer and you say, no, absolutely not. You reject it. It's a done deal, right? You wake up tomorrow morning, your financial situation has changed, and you decide tomorrow morning you've got to sell this house and you don't care. And you call me and say, never mind, I'm going to accept your offer. Can you do that? Can you go from a rejection to an acceptance? No, you already killed it when you rejected it. There is no reviving it. Now, let me ask you guys this. Could you call me the next day and make me a brand new offer with those exact same terms? Yes. You call me the next day, you wake up and you say, oh my gosh, I should have sold her my house. Okay, let me call her and make this right. You call me and you say, I'm making you an offer to buy my home under these terms. What 3 choices do I have? I can accept your offer, reject your offer, or counter your offer. Even though I made you the exact same offer yesterday and you rejected it, I'm still not bound because today we are dealing with a brand new offer. Okay, so rejection, there is no reviving it. There is no going back. When it's done, it's done. Your third choice, the offeree's third choice is to counter it. A counter offer is a rejection with a but. I'm good with all these terms, but this, and this. Did you just hear me say the counter offer is a rejection? I have rejected your offer. And now, in a sense, what I am doing, we're going to reverse these roles. And now I'm going to make you a brand new offer. Some of the terms will be the same, but they weren't exact. So now I'm making you a brand new offer. The offeree becomes the offeror becomes the offeree. Now the seller is making an offer to the buyer. I countered your offer. I rejected it. There is no going back on a counter offer. Once it's been countered, it's dead. Now the seller's making an offer to the buyer, and the buyer has 3 choices. They can accept it, reject it, or counter it. I'm going to have you guys dreaming about this weekend. There's a reason why I say things 20 times. I'm just saying. Let's see. Somebody says, what if if this is a seller of FSBO? So I have not brought agents into the mix yet. This is just contract formation between the parties. I will bring agents into the mix in just 1 second. Yep. Before we get agents, there is this magic moment in time when it goes from being an offer to a contract. And we have to have 2 steps to go from being an offer to a contract. The first step is that the last offeree has to accept. The last offeree has to agree to all of the offeror's terms exactly how they are. Step 1, we have acceptance. The next step, the second step, we have to have communication of acceptance. The person making the offer has got to be notified that their offer has been accepted. Do you think this is important? Yeah, definitely. Definitely. We need to know, this is one of the services we provide our buyers and sellers. We need to know this moment in time. We need to know when this goes from being an offer to a contract. And how we know that is we're looking for 2 things. We're looking for acceptance, and then we're making sure that that communication of acceptance crosses our contract communication wall. Good question comes in. Is this verbal? Is this in writing? Is this paper? Communication of acceptance is whatever form the parties agree to. So I could pick up the phone and call you and say, I've accepted. I could fax it, email it, text it, courier pigeon, whatever we agree to. We are not delivering the document. We are communicating the fact that I have accepted it. If I call you and say, I accept, obviously the next step I need to do is get you that written signed contract in your hand. Again, you guys, this does not say deliver the contract. This says communicating that you have accepted the terms of the contract. For your test, when you see that the last offeree has accepted the offer, for your exams, know that that means that it's been signed. In the real world, I need you to verify that, because in the real world, if you have verbal acceptance, you have absolutely nothing. For your exams, when you see that the last offeree accepts, no, I'm telling you, it has been signed. So we have communication of acceptance, meaning we've been told that the other person's offer has been signed. We will deliver the actual offer later. That's not what we're dealing with right now. We are dealing with notifying you that I have signed it. So let's see. I mentioned the other day, I'm going to mention it again now. I think when you guys see some of these test questions, they get like really long because you're going to have some counters and they're going to go back and forth. I really think you guys should draw the contract communication wall, because at the end, you need to see who's the last offeree to accept it and who's the last offeror to get that communication of acceptance. So I recommend drawing the wall so you can walk it back and forth. Buyer starts as the offeror, seller's the offeree. Counter offer, the roles reverse. Maybe another counter, maybe another counter. Those counters keep happening until the last offeree accepts it or rejects it. But for your exam, they want this magic moment in time. And I think it's best for you to take this big, long problem with a whole bunch of information in it and give yourself the visual so you can see who the last offeror is and the last offeree. Questions on this is important, not just for your test, but like for real life too. Questions on this. We need to know when we can officially call our clients and say, we're under contract. Yay. And that's what we're looking for. We actually define this in our contract as well. So we'll see this again. It defines, it's called in the contract, it's referred to as the effective date. So our contract will tell us when the effective date is. And the effective date is once I've had the last offeree accept, the last party sign, and communication of acceptance crosses the line. So back to our little scenario. So the buyer has accepted, which in pre-licensing world means they have signed it. And now to become official, communication of acceptance needs to cross the line. We need to see that the seller, in this case, that the offeror has been notified that their offer has been accepted. So let's go ahead and take our break. And when we come back, we're going to look at this contract communication wall when real estate agents are involved. What does that look like when we get involved? So let's take 10. Welcome back. All right. Cameras are on, cameras are coming on. And I am going to take attendance. We're going to jump back in. So again, this magic moment in time when it goes from being an offer to a contract, and we must have these two things. The effective date. This is the effective date of the contract. Most of the time, these two things happen on the same day. So most of the time we can get the last offeree to sign and we can communicate acceptance to the offeror. What if though? What if we are, we're up late at night in the throes of negotiations and the offeree signs at 11:45 p.m. and I don't get to communicate acceptance until I wake up at 6 a.m. the next morning? What's the effective date? The effective date is the next morning, the next day, because we have to have both of those steps. We have to have both of those things. So usually we try to have it all happen on the same day, but just be aware, if you sign it on one day and communicate acceptance on the next, the effective date will be the next. All right, let's bring agents into this mix. What does this look like when agents are involved? When it comes to contract formation and contract negotiations, communicating to me is just as good as communicating to my client. So once you tell me that your guys have accepted, I know they signed, that communication has crossed the line, and guess what? We are under contract. So let's look at our contract wall with agents. So on one side of the contract wall, we still have the buyer. We'll call them the offeror. But now with the buyer, they come with an agent. And on the other side of the wall, we have the seller with the offeree as the offeree. And now the seller comes with an agent. So let's walk through a scenario together. You are the buyer's agent. You take your buyer out this afternoon to show them property. Your buyer walks in the front door of one of your showings, and your buyer looks at you and says, "Oh my gosh, this is it. This is my dream home. This is what I've been looking for. Let's write it up. Let's make an offer." So you do your silent happy dance because you're still standing in front of them. You don't want to look like an idiot, so you do it inside, yay. So you get back to your desktop or laptop or your device, and you and the buyer go through the sales contract and fill in the blanks. How much do you want to offer? How much deposit do you want to put down? When do you want to close? We go through the buyer and we help them determine the terms of their offer. What are they willing to offer? Once you and your buyer complete the offer and any applicable addenda and seller disclosures, you have your buyer sign the offer. Buyer signs the offer. The buyer's agent presents the offer to the listing agent. The selling agent contacts the listing agent and says, "Here is my buyer's offer. We look forward to hearing from you. Thank you for your consideration." The listing agent contacts the seller and says, "We have an offer." The listing agent tells the seller, "You have three choices. You can accept it, reject it, or counter it." The seller is going to look at their listing agent and say, "Well, what should I do? What do you think?" So we're going to have an educated conversation. We're going to pull some comps and talk about some numbers and da-da-da-da-da. If the seller counters it, Those roles reverse. The seller becomes the offeror, making an offer to the offeree. The seller makes the changes to the counter, or to the counter. I'm all good with all the terms, but this, and this. The seller signs or initials the counter. And then the listing agent contacts the selling agent and says, we have a counter. Selling agent says, thank you, we appreciate your time, we'll be back in touch. They call the buyer and they say, the seller has countered your offer. The buyer's agent goes over the counter, goes over the details, and the buyer says, this looks good, I accept. Again, in pre-licensing world, when the buyer accepts in this case, what are they doing? They are signing it. In pre-licensing world, accept means sign. In the real world, we need to verify. So the buyer accepts, they call their agent. The buyer calls their agent and says, I have signed. I've accepted. When the buyer calls their agent, did that communication cross the line? No, that all stayed over here on this side of the line, right? So the buyer calls their agent, says we've accepted. The selling agent calls the listing agent. Now did communication cross the line? When the selling agent called the listing agent, congratulations, we are under contract. Because when it comes to contract formation negotiations, communicating to me is just as good as communicating to my client. What's the very next thing the listing agent should do in this case? Let's see, mouths move. Don't they need to call their seller and tell their seller the good news? And the call to the seller is not, are you sure you still want this? The call to the seller is, congratulations, you're under contract. We must have those two things. And when an agent is involved, we're standing in place. Communicating to me is just as good as communicating directly to my client. When you are negotiating on behalf of your buyers and sellers, we need to be available. Communication is so huge, you guys, and we need to be available. Answer the phone. But we need to be available. And look, I get it. Do we like to, I don't know, take a vacation every once in a while? Do we like to go to the beach? Yeah, the mountains. We're either beach or mountain people, aren't we, typically? I'm a firm believer, because you're going to meet some agents that never take a vacation because they're going to miss out on something, for example. And I don't know. I think if the president of the United States of America can take a vacation, then so can the real estate agent. That's just my thought on it. So I want you guys to go to the beach every once in a while. But if you're not going to be available in the throes of negotiations, you need to have somebody else communicate for you. You need to get with your BIC or your teammate or whatever, because your failure to communicate could negatively impact your clients. Let's say, for example, go back to our little scenario. I'm the buyer's agent. I have acceptance from my buyer. My buyer has called me and said, I've signed the offer. And as the buyer's agent, I say, awesome, that's great. I'm really busy today. I got several appointments and I'm going to be out and about. But as soon as I get home tonight, make dinner for my family and then sit down and clean up the kitchen and do the dishes and da-da-da-da-da. And as soon as I'm done with all of that, I will communicate acceptance of your offer. But what if another better offer comes swooping in for this seller that they accept before you cross that line, before your communication crosses the line? I don't know about you guys, but I don't want to be the one to call my buyer and tell them they lost out on their dream home because I didn't have time to contact the listing agent. I was too busy and I didn't have time to text or call or email or somehow notify the listing agent. Anybody want to be in that situation? I'm thinking no. So even if, once you know your guy signs, even if you have to pull over on the side of the road and send an email or a text and say, we've accepted, And I will send you the signed contract later tonight. Again, understand when we talk about communication of acceptance, we're not talking about delivering the signed contract. We're talking about communicating the fact that it's been signed. And that's where you need to pull over in a parking lot safely and notify the other party, we have accepted. Because now we have that acceptance. You're going to document that phone call. If you choose to call, you're going to document. That's why I like text and email, right? Because now you have a date and a time stamp. This is what time I told you. This is what time that communication of acceptance crosses the line. Is there a certain amount of time? That's a great question. A party has to accept or decline an offer. And the answer to that is no, as long as the offer or doesn't put an expiration date on it. So the offer or may say, my offer is good till 5 p.m. tomorrow. If we don't have acceptance by 5 p.m. tomorrow, it expired because I put that term on it. Let's see. Oh my gosh. Life's fun, isn't it? Okay, what if they don't see it or get it? It's not about when you receive it. It's about when you communicate it. And we're going to talk about, there's some certain things about when communication hits. So I'll talk just a little bit more on that. But again, we're not saying receive acceptance. We're saying communicating. We're saying giving that communication. And that's one place. If you're going to pick up the phone and call, I'm fine with that. But I need you to follow it up with a text or an email. Everybody with me? Because that's your documentation. So I gave you a 5 p.m. tomorrow expiration. Question is, during that time, can they accept other offers? Yes. The seller is free to accept any offer at any time that they wish. Even if the seller, some of you have been familiar with what's going on these last couple of years with the crazy market. And sometimes you may see, maybe in the remarks, it might say something like, best and final offers due by 5 p.m. tomorrow. We've put an all call out, notify the world. All offers due by this date and time. Even if the seller says, if we put something like that on, the seller is still free to accept any offer at any time. So if I put an all call out for 5 p.m. tomorrow, but the perfect cash offer comes in tonight, I can accept it. The seller is free to accept any offer at any time that they want. I think for your exams, for your practice exams, I think you should draw the contract communication wall, because we need to see, again, when the last offeree accepts it and when communication of acceptance crosses this line, we need to see that moment in time. So let's talk about the different methods of communicating. As I said earlier, communication of acceptance can happen however the parties agree. If we agree to communicate via phone or fax or snail mail, we'll talk about electronic methods in just a second. Whatever the parties agree to, we have a page in our contract that spells out how the parties want to be notified. How do you want to communicate with me from start to finish? So some traditional methods of communication, you can pick up the phone and call them, tell them your guys have signed, your party has signed. Fax, I think we said the other day, the fax is coming back. In some cases, the fax is a lot more secure than an email. I know I'm already hearing about it pop back up in medical profession. I wouldn't be surprised if we don't see it one day in real estate. Communication of acceptance could also happen by snail mail, the USPS, the post office. I know we're not using post office much anymore but is it still out there? Do we still have a post office? Yeah. So could communication of acceptance happen by snail mail? Guys, not everybody has an email address. Do y'all know that? Not everybody has an email address. So if they don't have an email address, can they communicate via via email? No, not unless you want to help them set it up, learn how to use it. And that just seemed like it kind of got out of my realm as a real estate agent. So we may have to use snail mail. If we're using snail mail, look with me on page 286. There's something called the mailbox rule. And what the mailbox rule says, the mailbox rule says communication of acceptance happens when the properly addressed envelope is placed in the federally related mailbox. Federally related mailbox meaning you either take it to the post office or you put it in one of those big blue boxes. Federally related mailbox is not at your house. It's not the one on your front porch or at the front of your driveway. So the properly addressed envelope is placed in the federally related mailbox. That's when we have communication of acceptance. It does not matter that the recipient won't receive it for another 2 to 3 days or weeks or whatever. What matters is when it was delivered. It's a place in the mail rule. The mailbox rule is one of the oldest rules we have in this country. It goes back to the days of the Pony Express, the Wild Wild West, way back then. But because we still have the mailbox, the other thing we need to understand about the mailbox rule, it only applies when we're communicating acceptance of an offer. The mailbox rule does not apply when we're negotiating, when we're terminating, when we're presenting. The mailbox rule only applies when we're communicating acceptance of an offer. And again, it's considered delivered when it's placed in the mailbox. Other methods of communication are electronic methods, email, e-signatures. Electronic means it's considered, communication of acceptance is considered delivered when it hits the recipient's inbox. Not when you send it and not when I open it. But when it hits the recipient's inbox, communication of acceptance has happened. Now, another thing you guys need to look out on your exams, back to that big long test question you're going to see. Another thing you need to be on the lookout for. Your test, I hate to say it tries to trick you, but what the heck? Your test may try to trick you. So buyer makes an offer to the seller. Seller accepts it. They notify their agent, I've accepted. And then the listing agent communicates with the selling agent that the offer's been accepted. We got our 2 steps, right? I got acceptance and I got communication of acceptance. What we need to be on the lookout for, that big long paragraph of the test question, is when that communication crosses the line. And we only need communication to cross the line once. So your test may say something like, the listing agent called the selling agent, and then they followed it up with a text message. When was the first time communication crossed the line? When they called. That phone call, that is what put us under contract. The text is a follow-up. The email, any other form of communication after that initial, after that first time, is just a follow-up. So if I call you and leave a voicemail, we're under contract. If I text it and then email it, that's just following up. So we need to know, because there's, again, different forms of communication in those test questions. And what counts, the one that puts us under contract, was the first time that communication of acceptance crossed the line. Don't let that distraction distract you. Questions? Same thing with the mailbox rule. If I'm mailing something, If I'm mailing something, I'm immediately going to follow it up with a phone call. Soon as I put it in that box, I'm going to, whoops. I'm going to call you and I'm going to say, I just mailed you our contract. Which form of communication put us under contract? Which one did it? Per the mailbox rule, it was when I put it in the mailbox. The fact that I'm calling you, I'm just letting you know it's there. I'm letting you know you can expect it in the next 2 to 3 days or weeks or whatever's going on with the post office at that time. Draw pictures on your test, you guys. It helps you take those big, long, distracting paragraphs and break it down. Back in the day when we were in person, it blew my mind after the test how many times I got blank paper back after the exam. Sit there and take a 4-hour test and you hand me blank paper back. What you do with your scratch pad? Gosh, you got it, utilize it. Draw pictures, draw it out, draw your thoughts out so you can see. Fair enough? Questions on this? Look at an example. An owner offers to sell to a prospective buyer. The offer states that acceptance must be made by email message only. One acceptable form of communication. Instead, the buyer leaves a phone message informing the seller he accepted the signed offer. Guess what? We don't have a legally binding contract because we have to agree on the ways that we're going to communicate. And if you say to me, email only, for example, there's only one acceptable form of communication. And again, we have a page in our contract that says, how do we want to be notified? How do we want to communicate? Questions? Bottom of page 286, we talk about termination of an offer. Please note, this word says offer. So different methods to terminate an offer. We've already said a rejection and a counteroffer terminates an offer. Other methods to terminate an offer. If the offeree, if the receivee fails to accept within any added time stipulated period. So again, if the offeror says this offer is good until 5 p.m. tomorrow, and we don't have acceptance at 5 p.m. tomorrow, that offer has been terminated because the offeror chose to put an expiration date on it. The offer could also terminate within a reasonable amount of time. Well, who determines that? Exactly. This is the good news about reasonable amount of time. The offeror, the giver of the offer, is free to revoke their offer at any time prior to acceptance. So if the offeror feels that we've hit this reasonable amount of time and they haven't gotten a response, they can take their offer back. They can revoke it. The offeror can terminate their offer at any time prior to acceptance. And then death of either party will terminate the offer. Fun fact, death is only an out when we're negotiating the offer. Once we are under contract, death is not an out. Once we are under contract, if either party passes away, their heirs are expected to carry on with their wishes. And if they can't or won't, the heirs suffer the consequences of breach that are spelled out in the contract. The party's intention was clear before they passed away, wasn't it? We got assigned a legally binding contract in our hand. Their intention was clear. Death is only an out when we're negotiating the offer. Once we're under contract, death is not an out. We'll see it in our contract. I know some of you are going, I'm sure. I'll show it to you. I got proof. I know. We don't always plan when that may happen. Is that unfortunate? You better believe it is. But they have a contract. Their intentions were clear because they have a contract. Contract law. So we'll see that. I know. We'll see that. I'm telling you, it's in your contract. It's there. We'll show it to you. All right. So up next, we're starting to get closer and closer to talk about our standard offer to purchase and contract. I would like you guys to make a note on page 287 to 293 in your book, 287 to 293. This kind of breaks down some of the bigger provisions of our standard form 2T. Now we're going to go through it. We're going to talk about it, but I do think because this breaks down and explains some of the more important provisions, some of the more testable provisions. But it was their intentions and not their heirs. So how their heirs responsible because the contract says that it's binding on the parties and their respective heirs. So if you're going to buy or sell a house, you may want to notify, you may want to have a conversation with your family, right? Because by the by, communication is so big, you guys, not just in real estate. Before we look at our contract, though, I do want to just go through most of our, so a lot of the commonly used forms. The North Carolina Association of Realtors also provides us for guidelines of how to complete. So I'm going off book for just 1 second. And what we're looking at now are the guidelines for completing our standard offer to purchase and contract. So just a couple tips to help us proceed. We're instructed to type if possible. If for whatever reason you can't type, if you don't have your device in front of you and you can't type it out, you can write legibly in ink. Please don't use a pencil or an orange crayon to complete a legally binding document. So we're going to print legibly in ink if we can't get to our device to type it. When we're completing the sales contract on behalf of our parties, we're never going to leave a blank. We're going to fill in all the blank spaces. If you have a blank that's not applicable, put N/A, not applicable. This is why there's 2 reasons why I want you guys to always fill in all the blanks. Reason number 1, I don't want the other side to think that I didn't complete the sales contract. I don't want the other side to think that I forgot to fill in that blank. So even if it doesn't apply to this transaction, by putting NA, I'm acknowledging the blank. The second reason why we're going to fill in all the blanks, that doesn't give the other side the opportunity to slip something in. So again, by identifying the blanks, I'm not leaving it blank for them to put something in. So never leave a blank. Be precise. Remember, our jargon doesn't belong. Our broker speak doesn't belong. Spell things out. Be clear. You need to ask yourself, if my buyer or my seller picked this contract up, could they understand these terms? Any change, addition, or deletion has to be initialed and dated by all parties. And then as real estate agents, we need to review these contract provisions with our parties. I'm telling you guys right now, buyers and sellers are not reading the contracts and the addenda and the disclosures. They're not. Why? Because they're relying on us, you guys. Remember, they hired us to help them. They hired us to assist them through this transaction. And helping them understand what they're agreeing to, helping them understand the contract provisions, it's part of our job. Blows my mind how many times I send something out for e-signature. I mean, some of these things, you add some addenda and some disclosures, some of these things could be pushing 30, 40 pages. And I'm sending 30, 40 pages to my buyers and sellers to sign. And I'm saying, let me know if you have any questions before you sign. And a minute and a half later, those signed pages are back in my inbox. That's some speed reading right there, isn't it? I'm telling you, they're not reading it. Every once in a while, you'll get a reader, but for the most part, they're relying on us. So it's our job to explain the various provisions to them. Also staying off book. Before we get into the contract, before we get into that conversation, I want to talk about some common provisions that you're going to see. I found that having this conversation up front, exposing them to you up front, we'll be better prepared when we review our contract. So, and this came up a few minutes ago. So I want to make sure that we have an understanding of something called a due diligence fee, a due diligence period, and earnest money deposit before we look at our contract. When they send back immediately, do I just go back and explain it to them? I've already explained it to them before I sent it to sign them. I've already told them, this is what I'm getting ready to send you. Why do you think I'm putting that in an email? Look it over before you sign. What am I documenting? That way they can't say, Julie didn't tell me to read it. Oh, that's not true. All right, so bear with me. Dealing with three different things here: due diligence fee, due diligence period, and earnest money deposit. DDF, DDP, and EMD. Broker speak. So let's talk about the fee and the deposit first. Understand, in our vernacular, a fee is usually non-refundable. A deposit sometimes is. So based on this slide and the past slide, do you think that the due diligence fee is refundable? Generally not. Fees are generally not refundable. Based on this slide and our last slide, do you think the earnest money deposit is refundable? Usually, could be. There's the what ifs, and we're getting there. So the fee is generally non-refundable. There's some exceptions. The deposit may be refundable. So let's go back to our fees and deposits. Let's break this down. A point in negotiation in our sales contract is something referred to as the due diligence fee. This is a negotiable amount, meaning the parties have to agree to this amount, that at the time of contract formation, the buyer is going to pay the seller. You just heard me right. At contract formation, the buyer is going to give the seller a due diligence fee, negotiable amount, whatever the parties agree to. Why in the world would the buyer pay the seller? What the buyer is paying the seller for with the due diligence fee is the buyer's right to terminate. The buyer has a due diligence period. Completely negotiable amount of time. Is it going to be a day? Is it going to be a week? Is it going to be a month? A completely negotiable amount of time. And during the due diligence period, the buyer has the right to terminate the contract for any reason or no reason at all. And if the buyer terminates within due diligence, the seller will keep the due diligence fee because that's what the buyer paid for. So in other words, if the buyer terminates within due diligence, they've paid for that right. The seller can't go after them in a court of law because they accepted money for that buyer's right to terminate. So that's what the buyer's paying the seller for. The right to terminate during the due diligence period for any reason or no reason at all. The buyer's due diligence period is their opportunity to learn as much about the home as they possibly can, do their inspections and their investigations. And at the end of their inspections and investigations, ask themselves, now knowing what I know, do I want to move forward and purchase this home, this property, or do I want to terminate? The buyer has to decide. Who remembers caveat emptor? Caveat emptor says the seller has to disclose what? The seller has to tell the buyer what? Not much. The onus to learn about the property is on the buyer. The seller doesn't have to disclose much. The due diligence period is the answer to that. Let's think about that, the answer to that. This gives the buyer an opportunity to inspect and investigate the property. So, due diligence fee, we go under contract, yay. Buyer owes the seller a check or an amount of money for the due diligence fee. They're paying for that right to terminate. So what if the buyer terminates during due diligence? The question is, they terminate during due diligence, do they get their due diligence fee back? Is a fee refundable? A fee is not refundable. So if the buyer terminates, they're not going to get their due diligence fee back. Why? Because they have exercised their right to terminate. This is what they paid the seller for. And now they are exercising their right to terminate. Fees are generally not refundable. Now there are the what ifs. What if the seller is in breach? What if the seller breaches? Could the buyer go after them for the due diligence fee? Of course they could. When we say typically, we mean if the buyer exercises their right to terminate, the seller's going to keep it. All right, I saw Nicole first, and then Joy, I'll get you. And I got other stuff to talk about too, so please bear with me. Yes, Nicole. Nope. All right, Joy.
Is there, so like with the due diligence fee, and I know you're gonna talk about the earnest money in a second, but with these fees, is it an addition to,
Hang on to that.
Okay.
Hang on to that. Yep, we're getting there.
okay,
I'm getting questions about the amount. You guys remember, it's a negotiable amount. The real estate commission, there's no formula. I can't tell you if the purchase price is this and the due diligence fee is going to be, there is no math formula. We don't have to do math with this. The commission is very helpful when it comes to explaining this negotiated amount. The commission tells us that these negotiated amounts, the due diligence fee and the earnest money, these negotiated amounts are whatever the buyer is willing to offer and the seller is willing to accept. So if you offer $1 due diligence fee, what are the seller's three choices? They can accept it, reject it, or counter. Does the seller have to accept $1 due diligence fee? That's what we mean by negotiable. It's one of those negotiable terms that forms the contract. We got to agree to all of the terms, and that includes the amount of the purchase price, the due diligence fee, and the earnest money deposit. Somebody's asking about the due diligence fee to lock the property, to take it off the market. Not true. We go under contract, the seller could still have showings. The seller still could allow showings. The seller could accept a backup offer. They could accept a backup contract. We will talk more about that. So that's a very common misconception. We're under contract, the seller's locked down. They could still allow showings. The only thing the buyer is paying for, they're not paying the seller to take their home off the market. The buyer's paying the seller for the right to terminate. Hang on to due diligence fee for just a second. We're going to come back to it. The other piece of money that comes up in our sales contract is the earnest money deposit. Could the earnest money deposit be refundable? Yeah. Fees, generally not. Deposits, maybe. So the earnest money deposit is also a negotiable amount, whatever the buyer's willing to offer and the seller's willing to accept. The earnest money deposit is paid to an escrow agent An escrow agent is somebody that's maintaining a trust account. So maybe the real estate firm has the trust account. Maybe we're going to use our closing attorney as the escrow agent. The escrow agent is an impartial third party. It's not the escrow agent's money. I'm just hanging on to it for you until you guys figure this out. Buyers put down earnest money deposit. They're showing their good faith. They're telling the seller, I'm a genuinely interested buyer. I'm not just out here kicking tires and seeing what's going to happen. Earnest money deposit shows the seller the buyer's good faith. Let's think this through. You're under contract to buy my house. Don't I have to find somewhere else to live? You're not wanting a roommate, are you? You're wanting me out of here. So as the seller, I need to know I got a serious buyer, because I either need to buy another house or sign a lease for a year or two. You guys with me? So the seller needs that reassurance, because they got to look for the next place to live. They got to look for the next home, and they need that reassurance. And the earnest money shows the seller the buyer's good faith. It shows the seller that they got some money in the bank and that they're serious about buying their home. The more earnest money you put down, the more you're telling the seller how serious you are. Does this make sense? Again, completely negotiable. So with the earnest money deposit, if the buyer terminates, is the buyer going to get their earnest money deposit back? And the answer is, it depends. What does it depend on? It depends on when the buyer terminates. So whether or not they'll get their earnest money deposit back depends on when they terminate. So let's talk about buyer breach. The buyer is not considered in breach until after their due diligence period. Due diligence period, we will learn in just a minute that due diligence period is an exact date and time stamp. The due diligence period is a time is of the essence. We agree on a date. Again, a day, a week, a month, a year, whatever. We agree on it. And when due diligence is up at 5 p.m. on that day, due diligence is over. The buyer can terminate up until 5 p.m. on that day. If they terminate after 5 p.m., now they are in breach. So they're not considered in breach until after due diligence, because remember that due diligence period is their right to terminate. They're doing their inspections and their investigations. They're learning everything that there possibly is to learn about this home and deciding during due diligence, do I want to move forward with, or do I want to terminate this transaction? So because of this right to terminate, if the buyer exercises their right and terminates within due diligence, they're not in breach. They're not in breach until after due diligence. So back to our earnest money deposit. If the buyer terminates within their due diligence period, guess what? They will get their earnest money deposit back. If the buyer's in breach, we are after due diligence. Not only will the seller get to keep the due diligence fee, but now the seller's going to get the earnest money deposit. So is the buyer going to get their earnest money deposit back? It depends on when they terminate. Terminate within due diligence, will get your earnest money back. Maybe you have a horrible home inspection show up, and this is wrong, and that's wrong, and this is broken, the electrical shot, and you got to buy a new roof, and the structure's getting ready to fall down. And you look at this report and you go, whoa, that's a lot more than what I bargained for. The buyer can exercise their right to terminate. They've lost the due diligence fee. They've lost the cost of the home inspection. I will get them their earnest money back, and they saved themselves how much? Thousands of dollars from purchasing this home and then fixing the structure and the electrical and the plumbing and all the other things wrong with it. They're conducting their investigations and their inspections. Buyer terminates after due diligence. Now they're in breach. The seller will keep the due diligence fee. And now they're going to get the earnest money deposit. If we terminate after due diligence, the due diligence fee and the earnest money deposit are the seller's liquidated damages. We said earlier today, liquidated damages are money damages that we agree to at the time of contract formation. We negotiate the due diligence fee. We negotiate the earnest money deposit. And the contract tells us the seller's liquidated damages are their sole and exclusive remedy in the event of buyer breach. So listing agents, when you get an offer, you need to make sure your seller understands. If the buyer never shows up to closing, all your seller's going to get is the due diligence fee and the earnest money. Listing agents, we need to make sure our sellers are good with this. Last couple of years, sellers have been doing good. Y'all, I'm not kidding this. They're getting 5-digit. In some cases, I've heard of 6-digit due diligence and earnest money deposits. Where are those people with that kind of money, right? But due diligence and earnest money fees have been outrageous the last couple of years. We're seeing that because it was the market. It was a super hot seller's market. We're starting to see those come down. And as that pendulum swings back into a buyer's market, you may get an offer one day for $50 of due diligence and $50 of earnest money, for example. We went from 6 digits to 2. Now you need to explain to your seller, if the buyer terminates after due diligence, this is all you get. Are you good with this? Remember, the seller has to find somewhere else to live. So have they have a contract to buy a home? Have they signed a lease? Your buyer terminates, that didn't terminate their contract or lease, did it? So the seller needs to think about what if the buyer breaches? Guys, there are no guarantees until it's a done deal and that deed changes hands. So buyer breach, we're after due diligence. Prior to due diligence, the buyer's exercising their right to terminate. After due diligence, if they terminate for any reason, including failure to get loan approval, they are in breach and the seller will get their liquidated damages. If the seller breaches, the buyer can sue the pants off of them. The buyer can take them to court for compensatory damages. The buyer could take them to court for specific performance. The buyer can sue the pants off the seller if they want in the event of the seller breach. Seller breach is much harsher than buyer breach. Why? The seller initiated this whole thing to begin with by putting a for sale sign in their front yard. Had they never made their property for sale, we would never be here today. So once the seller goes under contract, they are contractually obligated to carry through with what they started. I got some questions. I got some more to say. We also got to take a break. So everybody bear with me, take 10, clear your mind. I'll address the questions when we come back and we'll finish this up because we do have to talk about what happens if we actually make it to closing. No more of this, we're going to terminate. What if we actually get to closing? So we'll talk about that too after break. So take 10. All right. We are back. Okay, let me take attendance. Jump back in. Again, we've talked a lot of doom and gloom about, well, if they terminate, but you know what? Sometimes these things make it to closing. So what happens if they actually close? Let's say when we make it to closing. That due diligence fee and that earnest money deposit, they'll be credited back to the buyer. If I offer to pay, I don't know, we'll see this. Let me wait till we look at our contract to see an example. So whether or not the due diligence fee and the earnest money deposit is refunded or given to the seller or given to the buyer, none of that matters if we actually make it to closing. Whatever the buyer put down for due diligence and earnest money, does this make you feel better about putting down a 5-digit due diligence fee? That's money that'll be credited back to the buyer at settlement. The other thing that happens, that due diligence fee, that was going to show up as a debit to the seller. They've already received that money once at contract formation. So we need to reverse what we did when we go to closing. When we get to unit 21, we're going to talk about things that are credits and debits to both the buyer and the seller. So we'll see the things that are typically credits and debits to both parties. What question? I got a few in the chat here, so let me address these. So what questions do we have on due diligence and earnest money? This one says, does that fee sometimes get locked up to get off the market? Yeah, no, like we said, that's just the right to terminate for any reason or no reason. Somebody else says, unless they have a contingency, that's right. So you're not going to, you won't have to terminate the contract for loan approval if you guys have agreed to add a contingency. And I have taken attendance, so I see everybody back now. So if I missed you before, make sure you tell me you're back. What other questions do we have so far? We're getting ready to see it defined in the contract. You
So
were under the impression you don't get the feedback even if you make it to closing? Nah, man, we may be mean, but we're not cruel. Once you put that money down, if you go to closing, I'll credit it back to you. Kind of think of it when we get to closing, they're like down payments, right? They just went to different places. The fee went to the seller, the earnest money deposit went to the escrow agent, but you put that money down, so the buyer deserves to have it back. Did I hear?
so it's, I'm pretty sure I'm understanding. It's all part of the total sales purchase price of the
That's it.
property.
So if I, and we'll see that, I'll wait, because I think it's better if I give my example when I have something to show you too. So give me just 1 second. I'll give you an example.
Okay.
Good, Kydrea. Yep. We'll see you in a minute. Okay. So back to the book. Again, I just like to have that conversation about due diligence and earnest money. So now when we see it in the contract, now you've been exposed to it twice. So we're going to spend a little bit of time looking at your offer to purchase and contract. Again, it talks about it in your book, 287 to 293. I can't tell you your book's not out of date. So again, make sure we're always looking at the contract for the current information. What you're looking at 287 to 293 just gives you an idea about some of these more important provisions that we're getting ready to talk about. So if we go out to the online learning system, and in the unit 10 material, I have our standard offer to purchase and contract. And this is our new one that was just released July 1st. And I've gone through and highlighted what I think, what the syllabus says you guys should look at, the terms that you should be familiar with. And I'm going to go ahead and tell you right now, you guys, there's not much that isn't highlighted. So when we talk about looking at forms and documents, I think you should spend time with the offer to purchase and contract, because if it's in the syllabus, it's testable. If you see it highlighted, it's in the syllabus. So are the highlights a testable point? Yep. So I think you guys should spend some, I don't think you should sit down and read it word for word yet, But I do think you should have an understanding of what these different provisions are. Everybody with me so far? Head bobs? Okay, thumbs ups, take that too. All right. Offer to purchase and contract. Please note, first off, out the gate, this form serves two purposes. It serves as an offer to purchase, and upon acceptance becomes a contract. Thank you, Forms Committee, for giving us one for both. So we use this to present the offer, negotiate the offer. Once we have everybody's signature and that communication has crossed the line, we have a contract in our hand. As mentioned earlier, this form does come with guidelines. They're also available through NCAR. Your firm will provide them. So it's just referencing you the guidelines and assistance for completing this form. Another one of my super simple philosophies. I try to keep it simple. I really do. And another one of my super simple philosophies when I'm working in real estate life, I guess, when in doubt, find out. If you're not sure how to fill in a blank, stop and find out. Start with the guidelines. You'll have your broker in charge. You'll have seasoned agents that can offer assistance. Don't just fill in a blank for the sake of filling in the blank. You have references and resources to make sure that you're properly completing these things for your buyers and sellers. You guys notice here that B in buyers capitalized, that S in sellers capitalized? Usually if we're capitalizing names in our grammar, it's usually a proper name, a proper noun. Buyer and seller generally are not proper nouns, are they? But in this case, they're capitalized, referencing us to who we define as the seller and the buyer. So when you see something that's capitalized, it's not normally capitalized, what this is telling you is that we've defined it. We have specified this buyer, this seller. So they know what they're doing grammatically. The first provision of our offer to purchase and contract, we're going to spend defining terms. The first provision is the first, like almost 3 pages of this contract. And we're just going to spend time defining the terms. If you guys don't do anything else with this contract, I think you should look at the first provision because it defines things such as due diligence period, due diligence fee, earnest money deposit, effective date, etc. So the first thing we're going to define, who is the seller and who is the buyer. I need full legal names of all of the parties. And we're going to use full legal names of everybody. Do not put Mr. and Mrs. Campbell. My name is not Mrs. Campbell. You're going to put Ryan Campbell and Julie Campbell. We're going to identify us full legal names. For the sellers, this is all of the parties that have to sign the deed to convey the property and their spouses. Everybody that's got to show up to closing to sign has got to be on board here. Same thing with the buyers. Everybody that's going to show up on the deed, the new deed, we're going to list as the buyer, full legal name. Then we're going to define the property. We're going to identify whether or not the property will or will not include a manufactured or mobile home, whether the property will or will not include an off-site or septic, separate lot, boat slip, garage, parking space, etc. 8 years ago, 6 years ago, 10 years ago, I don't know, time gets away from me. They added these things to all of our forms, and you're going to see blue notes and red warnings. They're here for a reason, you guys. They're meant to draw our attention to them. So we have a blue note that instructs us if we do have a manufactured or mobile home, or if we do have an off-site or separate septic, lot, boat slip, etc., we are instructed to use one of our addenda, the additional provisions addendum. We'll look at this addenda. We'll look at several addenda once we're done talking about our offer to purchase and contract. But pay attention to those blue notes and red warnings. They're there for a reason. So we're going to identify the property, street address, city, county, zip. This is a North Carolina Association Realtor form for a property located in the state of North Carolina. So they went ahead and put North Carolina here for us. We don't even have to do that. Thank you, Forms Committee. In addition to the street address, you may or may not remember back in Unit 4, we said when you're conveying property, the street address alone is not sufficient. A sales contract is a document that's used to convey property. And so in addition to the street address, we also need, as much as we applicable, of the legal description. Street address is important, but so is the legal description. You told here we're told to complete all applicable. So deed book and page, subdivision, plat book. If it's not applicable, we're going to say N/A. Up next, we're going to define the purchase price. I need to make this big for a minute, then we'll make it small. But let's make it big so we can see it to have a conversation. Several different blanks here. We're going to go through these quickly and talk about what they mean, and then we'll talk about how this kind of looks, how this might work in practice. So first off, we have the purchase price, whatever the purchase price of the home is going to be, whatever the buyer is willing to offer, the seller is willing to accept. After the purchase price, we have the due diligence fee. How much of due diligence fee are we looking at? We're told it's made payable and delivered to the seller on the effective date and the means in which we're going to deliver it. Is going to be a cash, personal check, etc. So we'll actually put an amount here. We also have our earnest money deposit, made payable and delivered to the escrow agent that we're going to name in a future paragraph within 5 days of the effective date, again, under this method. Is going to be cash, wire transfer, etc. We also have initial earnest money and we have additional earnest money. Understand they're both earnest money. They both work the same way. One may be due and payable within 5 days of contract formation, the initial earnest money. The additional earnest money may be due and payable no later than 5 p.m. on this date, whatever date we agree to. And here is our first, time being of the essence, which means the additional earnest money, if any, is due by 5 p.m. on this date. If it's not been delivered by 5 p.m. on this date, the seller may have the right to terminate because the buyer didn't perform by that drop dead date and time. Some contracts use initial earnest money and additional. Some may say, I'll put up part of the earnest money now and I'll put up part of the earnest money later. Maybe I don't get paid again until Friday and I can't get the money until like next Friday or something. I've seen other contracts where we have initial, zero initial earnest money, and the only thing that's due is additional earnest money. When we say these are completely negotiable points, what I'm saying is there is no wrong way to proceed because it is all earnest money. It does the same thing. It's handled the same way. They just have different due dates. So completely, again, completely negotiable between the parties. The rest of these lines here, a loan assumption would be if the buyer is going to assume the seller's loan, meaning they're going to take over the seller's loan payments. We'll talk more about a loan assumption in units 14 and 15. We may have a situation where with seller financing, where the seller is going to finance the purchase. They're going to act as the bank, the lender, basically. In new construction, we might have a building deposit. One thing I like a whole lot about our contract, when we're familiar with it and we see it on a day-to-day basis, our contract, when there comes a need to use an addendum, our contract alerts us to that. So if we're familiar with the forms, we're familiar with the addenda, we know what's going on, the contract is very helpful in this. So you don't have to ask yourself, If I'm doing a loan assumption, do I need an addenda? The answer is, yeah, the contract's telling me to use the loan assumption addenda. So let it help you. Let it help you know what paperwork that you need. Let's see, somebody says the more earnest money, the more competitive. Absolutely. And that's why we've been seeing such high due diligence and earnest money fees the last couple of years, because buyers are being competitive. Remember, that's non-refundable. You tell me you want to buy my house and you're going to give me $50,000 due diligence. It's non-refundable unless I breach. Where do I sign? Right? Sounds pretty good, doesn't it? So the way this form works, and this is the example I wanted to go through earlier, but I wanted to have something in front of me. We start at the top here with the purchase price. So let's say we agree on a purchase price of $100,000. And then we negotiate the terms. Let's just say we have 5,000 due diligence and 5,000 earnest money, initial earnest money. We're agreeing to the terms. I've never seen or heard of a situation where every single one of these blanks is used. So we're not doing a loan assumption. We're not doing seller financing. We're not doing a building deposit. We're not doing initial. I filled in all the blanks, didn't I? It's clear how much money is changing hands. We filled in the blanks. The last line here is the balance. The top line, the purchase price, minus all the lines in between. It's probably not yet. Tells us, if we make it to closing, how much, is that right? I put the wrong number. I don't, I like math, but I don't go off calculator. Yeah. Don't second guess yourself. Okay, so we start with the top. I'm offering to pay you $100,000 for your home purchase price. We're going to negotiate the earnest money and the due diligence. We have agreed to 5,000 due diligence, 5,000 earnest money. Understand, I'm just making up examples here because there is no set amount. There is no formula. It's whatever the buyer's willing to offer and the seller's willing to accept. Negotiable points. So we deduct the top line from all the lines in between, and that tells us our buyer's balance, some or all, which may be paid with the proceeds of a new loan. So when we show up at settlement, this is how much, plus the other debits and stuff that the buyer owes that they'll have to pay. This is why we say it'll be credited back to you at settlement. They owe 100,000, they paid 10,000, now they only owe 90,000. Questions on the purchase price? Subject to, we'll talk about loan assumptions and purchasing subject to the loan. All that's coming in our financing units, 14 and 15. Next week, we get to put on a lender hat. Doesn't that sound like fun? We're going to act like a lender next week. Questions about the purchase price of the contract? We're just defining the money amounts. Again, we can see it. I'll let you guys read this. Just says what happens if either the due diligence or the earnest money is late, or if either of those checks bounce. That happens sometimes. So the seller, how they can proceed. I'll let you guys read that if you want. It's not highlighted. So up next, we're going to define the earnest money deposit. The earnest money deposit, may that be initial or additional, is required to be paid in connection with this transaction, shall be deposited and held in account by an escrow agent. The earnest money deposit will be credited to the buyer at closing or dispersed as required by this contract. I got a whole paragraph for remedies. Talks about what if anybody breaches, what are the remedies, and that's what that's referring to. The next thing we define, who is the escrow agent? Who is the impartial third party with a trust account that's going to hang on to our earnest money deposit for us? We'll talk about the trust account when we get to our license law and commission rule. You guys will read about that in the comments before we talk about it. So we'll talk more about what that looks like. Right now, we just need to understand there's going to be an impartial third party. Sometimes it could be the real estate firm if they have a trust account. I'm telling you guys right now, most sales firms are not managing a trust account anymore. So if the firm doesn't have a trust account, they can't act as an escrow agent. And in that case, we have our closing attorneys that have to have a trust account to pay all the proceeds of the sale. And they can serve as the escrow agent. This blue note is addressing what happens if the earnest money is in dispute. Remember, the escrow agent is an impartial third party. They can't decide what's going to happen to the earnest money if we terminate. The contract we're going to see says, if we terminate within due diligence, the seller will get the earnest money. I'm sorry, the buyer will get the earnest money. Let me say that again, please. Erase. If we terminate within due diligence, the buyer will get the earnest money. If we terminate after due diligence, the seller will get it. And even though that's what the contract says, if we terminate, both parties, buyer and seller, have to sign to agree to release the earnest money. And if they don't sign that, the earnest money's in dispute. And the escrow agent can't release the earnest money while it's in dispute. The parties have got to agree. Again, impartial third party. They're just holding it on your behalf. They have zero say in what happens to it. So that's what this note is addressing, is the disputed earnest money. Still defining things, we have the effective date. 2 steps. The last one that has signed or initialed, which is what we said accept. And the second step, such signing or initialed, is communicating to the party making the offer. So our effective date in our contract gives us those 2 steps, that magic moment in time when it goes from being an offer to a contract. Acceptance and communication of acceptance. Question comes in about clearing deposits. So for example, the earnest money, if we go under contract today, the buyer exercises their right to terminate tomorrow, which they can, we'll see in a second. The escrow agent has the right to make sure that that earnest money has cleared the bank before they release it. So tomorrow it hasn't cleared the bank yet. So they, wait that 5 days or 3 days. So absolutely, anytime you're holding money for somebody, you have the right to make sure that it's good funds. You have the right to make sure before you release it. Yep. Okay, so there's our effective date. Now we're going to define due diligence. Due diligence is defined as the buyer's opportunity to investigate the property, to decide whether the buyer, and the buyer's sole discretion, will proceed with or terminate the transaction. The whole point of due diligence is for the buyer to learn as much about the property as they possibly can. Caveat emptor, it's on the buyer to learn about the property. So the buyers learning as much about the property as they possibly can, and then deciding, now knowing what I know about the property, now knowing what I've learned about the property, do I actually want to buy this house, or do I want to terminate? The due diligence fee is a negotiated amount paid by the buyer to the seller for the buyer's right to terminate for any reason or no reason during the due diligence period. Back to that buyer that got the really bad home inspection report. First off, do we understand there's no such thing as a perfect home? So all home inspection reports are going to point out problems. Y'all prepare your buyers for this. The home inspector's job is to point out the problems. The home inspector is not going to go in the home and say, oh my gosh, this is a lovely home. You did really good. You chose wisely. The report's going to look scary. All it's going to say is this is broken, that's fixed, and this isn't working, and da 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 da. It's up to the buyer to decide. Do I want to close and deal with all this? Or do I want to cut my losses now and walk away? That's what they are paying for. The buyer's right to terminate for any reason. So we got the bad home inspection report, or no reason. They literally could wake up tomorrow and say, nah, I don't want to buy this house. That is what they pay for, the right to terminate. I had an agent once, her buyers terminated during due diligence because they learned that the sun set in the backyard and they like to grill out at night, and they didn't want to grill out with the sun shining on them. Is that a reason? Well, to that buyer it was. And they terminated. And the next house she showed them, she downloaded a compass so they could see where the sun set in the house. Is it important to the buyer? Obviously, it was important enough for them to lose their due diligence and whatever else they put into it. That's what we mean by their right, their choice. Any reason or no reason at all. The due diligence shall be the property of the seller upon the effective date. It shall be credited back to the buyer at closing. The due diligence is non-refundable, except in the event of breach by the seller. So there's a few exceptions to when the due diligence may be refundable. And basically those are exceptions if the seller breaches. If the seller breaches, they'll have to give back the due diligence. If they're not willing to do that, then the buyer can take them to court for consequential damage, or excuse me, compensatory damages. Then we have the due diligence period, beginning on the effective date and extending through 5 p.m. on whatever date we put in here, whatever date we agree to, time being of the essence. The buyer can terminate for any reason or no reason until 5 p.m. on this date. At 5:01, if they terminate for any reason, they're in breach. So we specify. That's pretty dang specific, isn't it? This date at 5 p.m. That's what we mean by time being of the essence. This is our drop dead date and time. They can terminate on the effective date. They can terminate at 4:59 p.m. and get their earnest money back. But they have to have notice of termination by 5 p.m. while they're still in due diligence. What questions do I have on due diligence fee, due diligence, period? Are we good so far?
So when it comes to new homes,
Hmm?
When the seller sets the due diligence fee, is the buyer or his agent allowed to negotiate?
Anything is negotiable. Remember, whatever the buyer is willing to offer and the seller is willing to accept. So let's say in the case of a builder, George, let's say the builder says, I'm not going to accept any offer if the due diligence fee is less than X amount. Do they have the right to reject it if an offer comes in, if the due diligence fee is less than X amount? Yeah, it's all negotiable between buyer and seller, whomever those parties may be. It's all negotiable. Now, several of you have been sharing with me in the chat throughout this conversation that you just bought a house or your girlfriend bought a house and y'all thought you paid too much for due diligence. This past market, yeah, you did. You absolutely did. Because due diligence fee were outrageous. Y'all think about it. This was one way that buyers could compete. If you have 45 offers in your hand, one of them has to stand out to you, right? One of them has to stand out. And wouldn't a high due diligence or a high earnest money? So buyers were almost forced to up their game to be competitive. Did the buyer have to offer 5 digits? No, but there was a good chance their offer wasn't going to get accepted. And that was the hard conundrum with buyers, and still is for the last couple of years. I don't want to put down all this money, but I want to get my offer accepted. So one tool we could use was negotiating this due diligence and earnest money to make your offer stand out amongst 39 other offers. Again, as that pendulum swings back and we come more and more out of a seller's market, we're going to be in a buyer's market. I guarantee you will see these come back down, but they'll still be there. Certain, I'm not kidding. I saw a 6-digit due diligence fee. Now it was a luxury home, right? We're not talking about an $83,000 house or something. I mean, this was a luxury home. But yeah, we've seen 5-digit due diligence fees, 6-digit due diligence fees. As that pendulum swings back, we're going to get back down to 4-digit. We're going to get back to something through the eyes of the buyer that seems more reasonable. It was a dog eat dog world if you were a buyer in the last couple of years. I think I've asked this before, but anybody try to buy a house in the last couple of years? Yep, my heart's out to you. It was tough. It was tough. Still not much easier. I had a teammate tell me yesterday he's competitive. He's got a buyer that keeps winding up competitive offers and the buyer's not willing to up his game and he's getting upset because the offers aren't getting accepted. Maybe this isn't the time for them to buy. I don't know. But if you want to buy, especially in this market, you got to be competitive. Yep. Oh yeah, over asking price, high due diligence, high earnest money. And guys, this is across the country. This was not just specific to, our little nook here in the world. Moving right along with our terms and definitions, we're still defining things. We first need to define settlement, and then we need to define something called closing. So we'll get to closing in a second, but before I do that, I have a confession to make to you guys. I feel like I'm going to church. I have a confession to make to you guys. We all use the term closing incorrectly. The truth is, in my entire life, and neither have you, none of us have ever been to closing. What we attend is settlement. So let's talk first about settlement. If you bought a house, you went to the attorney's office, you attended settlement. As a real estate agent, you will go with your client to settlement. Settlement is when we go to the closing attorney's office. They get the parties' signatures and their money. So buyer signs documents, seller signs documents. Buyer more than likely will have to bring money to closing. If the seller is underwater, that means they owe more than the property is worth. And the seller, in that case, may have to bring money to closing as well. We'll talk more about that when we get to financing. So settlement is what we attend at the closing attorney. Settlement is what we do when your buyers and sellers sit down and sign and bring their monies. We're going to agree on a settlement date. It's going to be after our due diligence period. Is it 5 days after? Is it 2 weeks after? Is it 5 weeks after? It's all negotiable. We're going to agree to our due diligence date. We have to agree to our settlement date. Once we leave the closing attorney's office, then the attorney proceeds with closing. Closing is the legal process, which is why not a one of us have ever attended closing. That's the attorney's job. When you get your license, you too will use it improperly. We all do. You'll look at buyers and sellers and say, we're going to go to closing on this day. No, you're not. You're going to settlement. But you're going to tell them closing because nobody understands settlement. So you will fall into that category as well. Trust me. For your tests, you need to know there's a difference between settlement and closing. You can only use those improperly once you get your license. That's like your rite of passage. But we need to know for our test that there is a difference. So closing is the completion of the legal process, which includes the following steps. Step 1 is settlement, which we already defined. Step 2 is the completion of a satisfactory title update, so the attorney can release their opinion and title insurance can kick in to protect the new owner. Step 3 is the closing attorney's receipt to disperse the necessary funds. So basically what we're saying here is the money from the lender. The attorney's got to collect money from the lender so they can pay it all out, get all that money and pay it all out. And then step 4 is the very last step of closing. And step 4 is when we're going to record the brand new deed. Then and only then is it a done deal. We go through settlement. It's not your buyers yet. After settlement, the attorney does closing, and the very last act of closing is recording the buyer's new deed. Now it's a done deal. Everybody works really hard to make settlement and closing happen on the same day. In a perfect world, it's all going to happen on the same day. The attorney e-records. We have e-recording now, so they don't have to drive down to the register of deeds. They can just submit it online. We get confirmation back. Most of our attorneys are scheduling settlement like no later than 3. So everybody has time to come in and sign, and they can do their thing and then record, because you know the register of deeds closes at like 5:00 on the dot. So we got to get in before they close. Sometimes things happen, you guys, though. Sometimes things happen that may delay settlement. Sometimes things happen between settlement and closing that may delay closing. We're going to learn later in our contract that we have a built-in delay, because delays in settlement and closing are so common. We all work really hard towards this date, but I always tell my buyers and sellers to have a plan B. Because if we're delayed, I don't want you sleeping in the U-Haul truck tonight. I want you somewhere safe and cool or warm, depending on the time of year it is. Delays just happen. Why do they happen? Pick a reason. Anything can happen. Anything could happen. If it's new construction, it's probably going to be delayed. What if we don't have loan approval yet? The lender's not quite there. They need another day or two. That could delay. Negotiated repairs. Anything can delay settlement. I don't have a crystal ball. I can't tell you what's going to delay settlement in this transaction. But what I can say is delays happen. They're common. Please, please have a plan B. What if we do settlement, the attorney does steps 1 through 3 of closing, and then they go to submit the new deed, and the daggum internet goes down? Is that going to delay things? Yeah, spectrum goes down. You lose power sometimes. Anything can happen. Just understand delays happen, and we need to be prepared. Questions on settlement versus closing? This red warning here is basically addressed to the attorney, from the attorney, if you will. It's let the consumer know that the attorney can't disperse the proceeds. They can't pay anybody until that deed has been recorded, until closing, excuse me, not until the deed. They can't pay anybody until, and the third parties like me and you, for example, we don't get paid until after it closes. Not settlement. You're not getting your check at settlement. You get your check when it closes. You will get an email from the attorney. It's my favorite email in this whole industry. Short, sweet, and to the point. They will email you and say, we are on record. That's when you know it's a done deal. That's when you know you can go back and get your check. That's when the seller gets paid, the lender, the attorney. Yep. Exactly right. The other thing that we'll address in our contract, the buyer should not be getting access until closing. The buyer should not be getting access to the property at settlement because it's not theirs until that deed is recorded. So they should not, and I know some of you may have examples where you stood up from the closing table and they handed you keys and said, congratulations. That's why I say should not. It's still the seller's home until that deed changes hands. Their insurance, all that good stuff. We'll talk about insurance. I got a whole unit dedicated to that. The last thing we're going to define here is special assessments. We talked about these a little bit already. Special assessments either come from a government to improve the property. Maybe they're going to install street lighting or sidewalks or something. Special assessments may also come from an owners association. So maybe they're going to redo all the roofs in the condominium complex or something. We define what a special assessment is here. We're going to address who's responsible for what later in the contract. And that's what that note is telling us. Question says, this says the lawyer here. Yeah, that's our closing attorney. Yep, so it's basically said that in North Carolina, we're a closing attorney state. The other thing I like about this, that it reminds us, you guys are going to get so sick of hearing this. Okay, it's not here. You'll hear it again. We are not attorneys. We cannot practice law. And we actually see that spelled out a couple times in the contract. So yeah, real estate attorney, our closing attorney. Questions about our terms and definitions is what, the first 2.5 pages? Like I said, if you guys don't do anything else with this contract, I think you should look at the whole thing. If you don't do anything else, read the first 2.5 pages. There's your definitions. There's your vocabulary words. Straight from the contract.
So now you said the one in our book is outdated or no?
Yes, yes. The contract in your book. Don't look at forms in your book. That one is, my book says 2018. What does y'all's book say? Mine's on page 271.
Yeah,
Ours
ours
says
is.
2018 too. Yeah, we're now looking at the 2023. So
Okay.
anytime you look at a form, never look at your book.
Okay.
Always come to the online learning system. Moving right along, the next provision is talking about our fixtures. Again, starting with a warning to the parties about not assuming that anything is a fixture. Fixtures are included in the purchase property. Remember, a fixture's intent is to stay. It's a fixture because it's permanently attached in a way that it's meant to stay. This contract 2T, gives us a list of things that, if we're using this contract, is considered a fixture. If you're using a different contract, the fixture list might look different. But if we're using 2T, we go into this agreeing that these things are fixtures. It does mention in any of their related device, anything like remote controls or anything like that. So for example, the garage door isn't really good without the garage door opener. That garage door opener is attached to the visor of your car, right? That thing can slip in your pocket. That's pretty personal property. Yeah, we can pick it up, move that thing easily, but because it operates the garage door, it's considered a fixture because it's a remote, because it's a device. You guys know how many times sellers have been halfway across the country in the moving van and realize that they still have the garage door opener attached to the visor of their car? That's why we have mail, FedEx, overnight, whatever. An awning just kind of comes out over the window. Sometimes they're metal awnings where they come out over the window. Yep. I know I had a seller once, he was cute. It talks about the window, the blinds and the shades. The rods are considered fixtures, but the fabric is considered personal property. So you leave the rod, what's attached to the wall. So anyway, our offer came in and the buyer asked for window treatments. And I asked my seller if he was willing to leave his window treatments. And he was like, yeah, that's fine, whatever. 2 minutes later, he called me going, what's a window treatment? I was like, it's like your curtains. He was like, oh yeah, that's fine. I said, okay. So that's why we have Google and agents, right? Also coming up with fixtures is smart devices. Our homes are getting really smart, y'all. I mean, our homes are getting really, really smart. So if there's any smart device that's going to stay, that's considered a fixture, the seller needs to unpair themselves from it, you know, remove the app, delete their account, and set it back to factory settings so the buyer can come in and, you know, hook up and start using those smart devices. So that addresses that. If there's any fixtures that we're going to exclude, other items that do not convey. So there's something on the fixture list, the seller's going to take it. We're going to exclude it. Remember, the parole evidence rule says the final written word will prevail. So if the seller wants to take a fixture, listing agents, we need to get that in the contract. If they do take a fixture, they're required, must repair any damage caused by removing the fixture in a good and workmanlike manner. So in other words, they can't jerk the ceiling fan out of the ceiling and leave wires hanging in a hole in the ceiling, right? They got to repair that. They got to fix whatever fixture, whatever they damage by removing the fixtures. If your buyer wants to be specific about how they want this done, we're told we can use an addendum. So again, let the contract help you. When a need comes up to use a form, they're going to let you know. After fixtures, we talk about personal property. Personal property is meant to go unless otherwise agreed. When we're completing personal property, I need you guys to be detailed. I need you guys to be specific. We talked about fixtures and personal property back in Unit 2. We said probably the number one, hands down, the number one personal property item is the refrigerator. When you're completing this for your buyers to get the refrigerator, I need you to be specific. Like, you know, 2-door stainless steel Whirlpool. If you can get a model number, get a model number. There have been cases in the past where the agent puts refrigerator. Buyer goes into their brand new home after closing, keys in hand, ready to go. They go in the kitchen, and standing in place as the kitchen is a little 2-shelf dorm room fridge. Did the seller do what they were contractually obligated to do? Did they leave a fridge? Yeah. Could the buyer's agent been specific as to which fridge? You know, sometimes you got the big fridge in the kitchen and then you got the drink fridge, the beer fridge in the garage. If you just say fridge, could they leave the beer fridge? Probably empty, no beer. So be specific when we're, I agree, people are people, you know? So what I'm telling you guys, how do we avoid this, Tim? we're specific when we're putting in fixtures and personal property. I do not encourage the practice of putting, you know, something like the refrigerator that was in the home at the time of contract formation. This could quickly turn down to a he said, she said thing, right? The buyer looked at one fridge, the seller said another fridge was there. You know, maybe you want to snap a picture so we know we're all in the same. But again, be precise. It needs to be clear and hear what it is that we are conveying. I'm going to go back for 1 second. I skipped this and I didn't mean to, but I did. Somebody asked about video cameras inside or outside the home. When it comes to any kind of equipment like that, the question is whether they're leased or not owned. So if your seller has leased things such as antennas, satellite dishes, receivers, security systems, alarms, if these things are leased, the seller can't sell what's not theirs. Oh, that's here. The seller can't sell what's not theirs. So if it's leased and not owned, then they will be excluded. Listing agents, we're having these conversations with our sellers up front. Do you have any equipment that you lease? They'll probably have to turn it back in and they can't convey it. So yep, that addresses that. Questions on fixtures or personal property? All right, let's take our last break. We come back, we keep looking at our offer to purchase and contract.
right. Nah.
Welcome back. I'm going to take attendance. Here. Okay. Terms and definitions, fixtures, and personal property. Up next, provision 4 is all about the buyer's due diligence process. Now, unit 21 is pretty much our contract to closing process. And there's a heavy concentration on buyers in unit 21. So we'll go through the process from the day we go under contract till that deed gets recorded, and the process about what all that looks like. So we're not, we'll look at this, of course, but we're not going to spend all of our time here because we know we're going to see it again. This is an important buyer's agents. This is the conversation we're having with our buyers to help us, help them understand and help us explain their due diligence process. And you guys will note, it starts with a big red warning. And within that red warning, we start with a sentence that's all caps and bold. Important to discuss with your buyers. Warning, the buyer is strongly encouraged to conduct due diligence during the due diligence period. If the buyer is not satisfied with the results or the progress of their due diligence, buyer should terminate the contract prior to the expiration of the due diligence period, unless the buyer can get an extension from the seller. What do y'all think? Is the seller contractually obligated to extend due diligence? Nope. Seller is not obligated to grant an extension. If we find while we're in due diligence that we need more time, we can always ask. There's no rule that says that we can't ask for more time. Make sure you and your buyers know that the seller is not obligated to grant that extension. What's something that might make the seller consider an extension? Nothing speaks louder than what? Money. Maybe we can negotiate this. If you want more time, maybe the buyer offers more money. Maybe they offer more due diligence fee. Again, this is all part of the negotiation. I call this round 2. If we are asking either party to reconsider terms to amend something that we previously agreed to, things to consider. I'm getting to repairs. Yep, we're going to talk about that in just one second. This is important. I think, again, just a common misconception. Although the buyer may continue to investigate the property following due diligence. Guys, please remember, the misconception out there is that the buyer has to do all their inspections in due diligence. The misconception is that at the end of due diligence, the buyer can't inspect anymore. And that's not true. Because remember, what the due diligence period is for is the buyer's right to terminate. They can keep inspecting and learning about the property up until settlement. All they lose at the end of due diligence is their right to terminate. So please don't think that investigations stop at 5 p.m. on this date. The buyer is learning about the property. We're going to talk about something in just a second called the final walkthrough. The buyer's still learning about the property up until settlement. All they're giving up at the end of due diligence is their right to terminate and get their earnest money deposit back. So buyer's failure to deliver termination will constitute as a waiver that the buyer has any right to terminate this contract. Again, in seller breach, that kind of changes everything. So we'll see that when we get to those paragraphs. Again, I'm a big fan of using the forms. If we're familiar with the forms, we can allow this to put words in our mouth. Buyer's agents are the ones that are explaining this process to the buyer. And if you're familiar with the forms, if you're familiar, it helps make that explanation easier. Please do not sit down and read this to them. But when we're familiar with it, then puts words, it gives us words to use. The next thing this does is it gives the buyer a list of things that they should consider inspecting and investigating during their due diligence. And number one is loan approval. The loan process is the longest part of the contract to closing process. So buyer's agents, we want to make sure that the due diligence period is enough time for the lender to work through their process. It is really, really rare to get final loan approval while we're in due diligence. Really rare to get final loan approval while we're in due diligence. Hopefully, what we can get in due diligence from the lender is a pretty good idea about how this loan looks. There's no guarantee, but based on the lender's pretty good idea, the buyer either feels comfortable moving forward thinking they're going to get loan approval, or the lender's pretty good idea is, yeah, this isn't looking good. So we want enough time for the lender. We want the appraisal back. We want enough time for the lender to get that pretty good idea. During due diligence, if you've never worked with this lender before, you're a buyer's agent, and you've never worked with this lender before, pick up the phone and call them and ask them, how much time do we need for our buyer client? Ask the lender. That may depend on how much time we're asking for due diligence. We're reminded that there are no loan or appraisal. It's weird. Loan or appraisal contingencies. So that's what this blue note is addressing. If we do add a loan contingency, then we need to contact an attorney. I'm getting questions. I'll get you guys in just one second. Let me get through this little section. And then also in the buyer's due diligence is the property investigation. This is what we're going to spend time talking about in Unit 21. So some of the various inspections, the buyer should be encouraged to review HOA documents. So here's our covenants, bylaws that we talked about back in Unit 6. We want to make sure the buyer is securing homeowners insurance during this time. They've ordered the appraisal on the property. We'll talk about that. We've talked about the survey, making sure everything's in compliance with zoning. Is it in a flood hazard? Utilities and access, streets and roads. We've already talked about whether or not the streets are public or private. Again, all things that the buyer should be investigating and learning about. And the other thing to understand about this list, you guys, this list is not all inclusive. Meaning if your buyer wants to investigate or inspect something that's not on this list, our answer as their agent is, okie doke, let's do it. Because remember, if it's important to my buyer, then it's important to me. So if my buyer wants to investigate or inspect something, we say, cool. We do not look at the, oh, you don't need to worry about that. It's fine. Don't worry about it. If it's important to them, then it's important to me. I'm not the one buying this house. So if they want it inspected or investigated, this list is just meant to give them an idea of things that they should consider. All right, let me go back and get some questions. What about repairs? We're going to talk about repairs. We'll address that in just one second. Is it a good idea to encourage our buyers to get pre-approved at the beginning of agency? Yes. So once we do our disclosure and we figure out how we're going to proceed, our next question is, have you talked to a lender? What we get to show the property to get your buyer under contract is a pre-approval. It's not a final loan approval. So we'll talk about that process and what comes when. That's coming in our financing units. What about the 1 week extension upon closing? I mean, yeah, we can always ask for an extension. If we get to where closing or settlement are delayed, we have that extension kind of built in. So we'll see that provision in just 1 second, or probably next week, actually, by the time we get to that page. It's further down. Also, during the buyer's due diligence, they need to notify the seller if they have to sell or lease an existing property in order to buy theirs. I'm not creating a contingency. We're just telling the buyer, if you got to sell or lease a property before you could buy, it is recommended that you seek to close on that other property prior to the end of your due diligence, or be reasonably satisfied that closing on your other property will take place. We're not creating a contingency. We're just letting the buyer know this should be handled during due diligence, if at all possible. Repairs and improvements. Who remembers what the seller is required to repair? What do they have to fix? Oh, Julie, that's kind of a trick question, wasn't it? What do they have to fix? Nothing. They don't have to agree to do any repairs. Homes in North Carolina are sold as is. So as far as repairs, unless the parties agree otherwise, super important sentence. This property is being sold in its current condition. Isn't that just a fancy way of saying as is? The seller may, but is not required to engage in negotiations for repairs. So here's the deal. Buyer conducts their inspections, investigations. They learn everything about the property that they possibly can. And generally, they ask the seller to do repairs. There's no law that says the buyer can't ask. The worst thing that the seller can say is no. The seller can't terminate because the buyer asks. So the buyer asks, the seller says no, and now the buyer knows. Now knowing what I know, I'm buying this property in its current condition because the seller's not going to fix anything. Do I move forward with or terminate this transaction? If the seller agrees to do repairs, maybe they agree to do some of the requested repairs, maybe they agree to do all of the requested repairs. If they agree to do any repairs, we're going to have an amendment. And what we're amending is this one very important sentence. We have amended, instead of this property being sold in its current condition, now this property is being sold under the condition that the seller does this repair. The amendment, well, I got a form for that, never worry, I got a form for that. It makes the seller contractually obligated to do that agreed upon repairs. They sign it saying, yep, I'll do it. And we need all of this to happen. I need the request. I need the seller to agree in writing with a signature while we are still in due diligence. Because if the seller won't sign that, the buyer needs to decide if they want to proceed with or terminate this transaction. Does this make sense? So we need the repairs to be agreed in writing and signed while we are still in due diligence. The repairs themselves don't have to be complete until prior to settlement. Once the seller agrees to do it, they're contractually obligated, and they are not offering this property in its current condition. They're now offering the property in this condition, except for the repairs that I've agreed to do. Questions? Let's see what we got here. Buyer can negotiate price based on what it will cost to repair. Sure, you can offer whatever you want to. The seller's three choices are to accept your offer, to reject your offer, or to counter your offer. So could you come into this knowing you have repairs and you want your offer price to reflect that? Sure. In this market, I hate to say it like this, but in this market, you're not going to get far with it. You got to wait for a buyer's market for that. for that. Is that also true with VA loans? VA loans are different. VA properties are different. VA loans are just different. So we'll talk about the different loan types when we get to our financing units. Do some firms require the buyers to be proof for mortgage before showing him? I don't know if it's a requirement, but I don't know why you would show property to somebody that you don't know if they can afford to buy it or not. So Y'all save yourselves time and gas and effort and energy and require your buyer to talk to a lender before you start showing them property. I don't think there's a requirement. If you don't, hear me now, that's all right. You'll spin your wheels with one buyer that didn't get approved, and then you'll learn your lesson pretty quickly. The other thing I know, sellers aren't even going to consider your offer if you don't have that pre-approval letter. So yeah, let's go ahead and get it now before we show property. So we all know we're on the same page and we all know what it is that we're dealing with. Questions on repairs. Buyers generally don't like this, by the way. The fact that sellers aren't required to do repairs. Buyers think I'm spending all this money. As a matter of fact, in this market, I'm paying more than purchase price. Why doesn't the seller have to fix something? Why don't they have to deliver me a perfect product? Because North Carolina is a caveat emptor state and homes are sold as is. What do other states look like? I have no clue. Still in the buyer's due diligence, their obligation to repair damage is what we were talking about earlier. If any of the buyer's inspectors or investigators damage the property, the buyer, at the buyer's expense, shall promptly repair any damage to the property. So if the home inspector, if they, punch a hole in the wall with the ladder, whoops, by accident, I backed into the wall and I punched a hole into it, the buyer is on the hook to pay for that. And that another good reason to make sure that we're recommending good home inspectors and not going to Google and finding anybody that claims to be a home inspector. Understanding accidents still happen. Indemnity, if you're indemnifying somebody, you're holding somebody harmless. So other than the losses and damages addressed in the contract, other than the losses and damages that we've already agreed to, basically the parties are agreeing to hold each other harmless. And then the last thing here, that's kind of legal jargon in a contract. And then the last thing, or next to last thing, the buyer's right to terminate, provided that the buyer has delivered the due diligence fee. Buyer shall have the right to terminate this contract. Here it is again, for any reason or no reason. All they have to do is provide written notice of termination during the due diligence period, time being of the essence. They don't have to tell the seller why they're terminating. They're exercising their right to terminate for any reason or no reason at all. Why? Doesn't matter. All we need to know is that the buyer is exercising their right to terminate. If the buyer timely delivers a termination notice within due diligence, this contract shall be terminated and the earnest money deposit shall be refunded to the buyer. So if we terminate within due diligence, the buyer will get their earnest money back. As a buyer's agent, worst case scenario, we find a bad home inspection, or we hold we're not going to get loan approval, or we can't afford insurance, whatever. As a buyer's agent, the best thing I can do is get you to terminate within due diligence so I can get you your earnest money back. Getting you something back is better than getting you nothing back at all, right? So buyer's agents, we're a huge piece, a big part in keeping this due diligence moving, because we understand the importance of the buyer making the decision within due diligence of whether to proceed or terminate. So keep these gears going. Again, more on the contract to closing process. That's pretty much unit 21, we get to go to closing. Unit 21 is one of my favorites. We'll go to closing. So we'll talk contract to close day one till the end. This last thing here might be one of the most important things about the contract. Closing shall constitute acceptance of the property in its then existing condition unless provided otherwise made in writing. When that buyer goes to settlement, they need to understand what they're signing is the property as it stands right now. We will see something about the final walkthrough. Let's talk about the importance of the final walkthrough. Buyer's agents and buyers should be conducting the final walkthrough as close to settlement as they possibly can, so the buyer knows what it is they're accepting. If you've never seen this home vacant, you need to do the final walkthrough. Because now the seller's moved out and we're seeing it vacant for the first time. What if, for example, the reason that this picture is here is not because it's pretty and we like it, but because it's hiding a big hole in the wall. And we don't see it until the seller moves out and takes this picture with it. If the buyer goes to settlement and signs with the property in its then existing condition, they're signing, agreeing to take the property with the hole in the wall. If they don't want to take the property with the hole in the wall, they shouldn't go sign and accept the property. That's a tough call to make, isn't it? And I can't make that call for my buyer. That's on them. Either you go and sign, or we rehash this thing out and have the seller fix this hole before you sign. Are you guys with me? They need to understand, if you go sign, it's a done deal. You're not going to be able to call the seller the next day and say, yeah, when are you going to come back and fix this hole? What do you think the seller's going to say? You're so funny. Thanks for making my day. Right? If we want this hole addressed, it's got to be accepted, or it's got to be addressed before we sign, because closing shall constitute acceptance of the property as then existing condition. We just gave the example about whether or not the home was vacant or not. If you've never seen it vacant, you definitely want to. Guess what? If you've seen it vacant the whole time, you still want to do the final walkthrough. Because if it goes down, the last thing we want is for your buyer to look at you and say, I would have never signed had I known that. So one thing you can do to protect yourself is the final walkthrough, so they know what they're signing. I try to do my final walkthrough on our way to the closing attorney's office. We go to the house, we look at the final walkthrough, and then we go to the attorney's office and do settlement. They got choices. Either you sign and accept, or we figure this out before you do. That's tough, isn't it? We all think we're going to closing today, and then you discover this hole. Would that be an omission? Remember, caveat emptor. What does the seller have to disclose? Nothing. And guys, we're not going to mess with personal property. I'm not going to walk in the seller's house and take all the pictures down and see if there's a hole. Right? I mean, we got to ask these questions. Sure, the home inspector isn't going to mess with personal property. That's why we need to see it vacant if we never have before the final walkthrough. Yes, I've had this come up. Yes, I've had to look at buyers and say, you have a choice. I mean, we did the final walkthrough once and the house was trash. I guess the sellers didn't think that they had to throw garbage away for the last couple of years or whatever. I don't know. It was trashed. And my buyer said, oh my God, what do we do? You have two choices. You either go and sign and accept this trash, or we call the listing agent, telling them we're going to delay closing and the seller's going to come clean this up. I can't make that decision for the buyer. Another good reason to have them have a plan B. Because if they don't have a plan B, they might feel that their only choice is to go and accept the property so they have somewhere to sleep tonight. And not in a U-Haul truck. Let's see. Sorry about that. Did a lot of this happen? You know, that's a great point. Somebody asked about the last couple of years. Did all this stuff happen? Probably not. Did that make it right though? Guys, one thing I learned early in this super strong seller's market as we were entering into, especially as a buyer's agent, as strong as the market was, that did not negate my duties and responsibility of a buyer's agent. So even though it was swift and fast moving, I still had duties and responsibility to my buyers to explain these things to these buyers. Yes, I may have had to talk a little faster because things are happening fast, but that's still my responsibility. That's still my job as their agent, is to make sure they understand these things, regardless of how swiftly things are moving. So did this stuff happen every day? Might be happening right now. Oh, you don't need to worry about the final walkthrough. We've seen it 20 times. Just go sign. Could the agent get a phone call after closing when the buyer gets their keys and walks in the front door and sees something they weren't expecting to see? Who are they going to call first? Do the final walkthrough to protect yourselves. Questions about the buyer's due diligence process. When I took post licensing, let's see, I got my license in 08. So I either took post licensing the end of 08 or the first of 09, somewhere in there. And my post licensing instructor shared a story with us that stuck with me all these years, and I hope it sticks with you guys. She told us about her very first buyer transaction ever. She said, I was young, I was excited, I was wet behind the ears, and they were getting ready to go to settlement. She looked at her buyers and said, do y'all want to do the final walkthrough? And her buyer said, no, we're fine. And she said, okay. So they went on to settlement. Everybody signed. The buyer got keys. The buyer got the deed. The buyer got keys. We thanked each other in the parking lot, went their separate ways. Buyer goes to their brand new home, calls the agent and says, you've got to come over here and look at this. Dread, worry, fear, the whole way there, the whole way there. She goes to the house, they open the front door. Luckily, they're laughing. This is the good news. They said, we didn't know how to explain this. We should have done the final walkthrough. We've never seen this home vacant, and we should have done the final walkthrough. She said, what's up? So they took her back to the bedroom, the master bedroom. And she said it looked like the New York City skyline. These guys painted around the bedroom furniture. They painted around the dresser, and they painted around the headboard and the nightstands. Sellers moved out. We didn't do the final walkthrough. Buyers walked in and thought, why didn't you just put those things on sliders and move them to the center of the room and cover them? I don't know why people do what they do. But you know the lesson that my post-licensing instructor learned? Do the final walkthrough. Luckily, those people had planned on painting that room anyway. But could we imagine the problems had they not? So do the final walkthrough. Let them know what they're buying. No, I wanted to see it too. She said, I felt like I was standing looking at the New York City skyline. Gosh, that's a lot of energy to paint around a dresser, I would imagine. Like I said, put it on a slider, move it out in the middle of the room, put a tarp over it. Real estate's fun, Tim. We don't have to make stories up in this industry. They just happen. Questions on the buyer's due diligence. Question comes in, what if there's something wrong with the property during the final walkthrough that wasn't there before? We have a provision that addresses if the property wasn't in the same condition as it was at contract formation. So we'll see what happens with that. And again, bottom line, they come down, they have a choice. Either go on to closing and accept it, or we delay closing or settlement and accept it, or we delay closing until we get this addressed. So yeah, sometimes things break after we go into contract, right? So the buyer would kind of, because they're not buying the property that they went under contract for. Yep. How about insurance? Insurance will kick in as soon as that deed changes hands. We got for it while we're in due diligence, but it's not going to kick in until they become the owner. We got a whole unit on insurance, so we'll talk about homeowners insurance in unit 13. This next little provision is buyer representation. These are things that the buyer's representing to the seller. The seller should be able to rely on the accuracy of this information, when they're deciding whether or not to enter into a contract with this buyer. So the first thing the buyer is going to represent to the seller is, how you going to buy? You going to be a cash buyer? If so, we're going to need verification, some kind of proof of funds from your bank that you do have the cash that you claim that you do. Or is this buyer going to get a loan? And if they are going to get a loan, remember, seller's not even going to tolerate an offer without a pre-approval letter. So we've talked to a lender by this point. We talked to the lender before we ever showed them house one. Yes. So we've talked to a lender. We know the specifics of the loan. We have the pre-approval letter. We're just representing to the seller what the terms of that loan is. We're going to talk about FHA, VA, conventional. All this is USDA. All this is coming in our financing units. The buyer has to represent if they do or do not have another property to sell or lease. Again, I'm not creating a contingency. The buyer is just representing to the seller, I do or do not have to sell or lease another property in order to qualify for a new loan. So if we do have to sell another property to qualify for a loan or otherwise to purchase your home, the seller's encouraged to get information about that contract before they accept this offer. And again, you guys, the last couple of years, you got 40 offers in your hand and one of them says, I can't buy your house until I sell mine. That offer is getting pushed to the side pretty quickly, isn't it? And we're going to look at the other 39. We're not creating a contingency. As a matter of fact, our blue note says this contract is not conditioned upon the sale or lease. If the parties agree to make this conditioned on the sale or lease of another property, a contingency addendum should be drafted by our attorney. We do not have a form for this. So if they do agree to add a contingency, we have an attorney draft. Buyer needs to represent performance of other financial obligations. So if they're facing like bankruptcy or something, the buyer should share that with the seller. That may affect the seller's decision. The buyer has to represent to the seller whether they have or have not received the RPODs and the MOG. Remember, we talked about these seller disclosures back in Unit 8. The buyer's not saying, I like the way you complete these. You said yes or no. The buyer's saying, I've received it. Remember these forms. These are our mandatory forms with optional disclosure. The seller has every right in the world to say no representation. So the buyer's not acknowledging that they're happy with the way these forms are completed. They're just acknowledging that they have been received. So either the buyer has received a copy of these forms or they have not received a copy of these forms. If they have not, that may give the buyer the right to terminate and get their due diligence feedback. So what we're representing to the seller is, I haven't gotten these forms yet. And if I don't get them back by this window, I have a right to terminate and take my due diligence feedback. So we're letting the seller know if we got them or not. Same thing, little exercise with the MOG. Either they have received it or they have not. Buyer obligations. We already defined a special assessment. Now that we're talking about buyer obligations, they're saying they're going to take title to any special assessments that may be approved after settlement. It's proposed right now. It's on the table. They're having a discussion about it, but it hasn't been approved yet. We haven't gotten everybody to vote aye yet. So anything that's approved after settlement will be the responsibility of the buyer. Special assessments. Buyer's responsible for certain costs of all of their due diligence. The buyer's responsible for paying for their costs associated with their due diligence, their inspections and investigation. When we get back to a buyer's market, We may be seeing sellers pay for some of buyers' closing costs, completely negotiable. We've been seeing a big zero the last couple of years. But as we get back to a buyer's market, I'm not saying who's paying for it. I'm telling you who's responsible for it. So the buyer's responsible for their costs related to their due diligence period. And then the last piece here about the buyer's authorization to disclose. When we go under contract, once we have a signed contract in our hand, the agents get a copy of the contract, the lender needs a copy of the contract, the closing attorney needs a copy of the contract, the appraiser will definitely get a copy of the contract. And that's what this authorization to disclose. This is basically saying that anybody that needs a copy of this contract to do their job to make this happen should get a copy of it. So you don't have to call your buyer and say, can I give your contract to the lender? We need to, so they can do their part. We talk about these different provisions, you guys. 4, 5, and 6 are all about the buyers. So as buyers agents, 4, 5, and 6 are the ones that we're trying to have conversations about, their duties, their due diligence, their obligations, and their responsibilities. Questions? The answer to that is, it depends. We got to consider a multiple offer situation. Question comes in, how do you rank offers? Which one's better? Which one's the best? We got to look at all the terms. We got to consider all the terms. And we also have to consider the needs of the seller. So there is no typically best. It's per transaction, per seller. And it's not up to me which one we accept, is it? Nope, it's up to the seller. I'm providing the facts. I'm going to sit down and go over all 40 offers with my seller. I'm going to make sure they understand. I can offer my advice, my opinion, sure. But bottom line, which one we accept, it's going to be up to the seller. Yep. So if 4, 5, and 6 are about the buyers, provisions 7 and 8 are all about the sellers. So listing agents, these are the conversations we're having with our sellers. Again, we start with some seller representations, information that the buyer should be able to rely on when deciding whether or not to enter into a contract with this seller. So the seller needs to represent how long they've owned the property. Some lenders have a certain length of ownership, for example, before the seller can sell. Some lenders care about how long the seller has owned the property. So the seller needs to represent their ownership. The seller needs to represent if the property is built prior to, what's our magic year with lead-based paint? 1978. If it was built prior to 1978, we're instructed to include the lead-based paint or lead-based paint hazard disclosure addendum. Also a new, as of July 1st, red warning that reminds the seller of their obligation to disclose the known presence of lead-based paint. Understand these lead-based paint laws are federal laws. So this idea of North Carolina is a caveat emptor and the seller doesn't have to disclose, federal law overrides that. This is one of few things that the seller has to disclose. And that warning was just added on July 1st to allow us to have a conversation with our clients and the sellers, particularly about their duty to disclose what they know. Seller's going to represent if they're in an owner's association, if they're in an HOA. If they are in an HOA, the seller should be providing any related documents. So anything pertinent to the HOA, the buyer needs to review the HOA covenants and rules while we're in due diligence. By the way, this same list shows up in our listing agreement. So we can have this conversation with the sellers back in the day when we're listing it and tell them a good buyer's agent is going to ask for these documents. So let's have them start gathering it now so we'll have it ready when we go on the market and a buyer comes along. Specifics about the HOA, who is the property management of the HOA, what the dues are. HOA dues are usually X amount per month, per quarter, per year, something like that. So just letting the buyer know what those HOA dues are. Whether or not there's a fuel tank on the property. We talked about underground storage tanks in unit 20. So to the best of the seller's knowledge, there is or is not a fuel tank. It's currently in use or not, it's owned or leased, it's above ground, below ground, what type of fuel is in it, who's the vendor. So the seller's representing to the buyer information about the tank, the fuel tank, if any. And the seller also needs to represent if there are any existing leases and tenants in the property. In North Carolina, the buyer buys honoring existing valid leases. They acquire the tenants. So the property is or is not subject to lease. If it is, we are instructed to use our additional provisions addendum, which spells out the terms of the lease. It requires the seller to turn over, the documents and the lease and the financials and all that good stuff. We'll look at the additional provisions addenda or talk about it more next week. We'll talk about several of our addenda, commonly used addenda, certainly not all of them. We're an industry of forms. Have you guys ever heard that before? We love our paperwork in real estate. So there's an old joke that says, I got a form for that. And it's not real funny because more than often it's true. We got a form for most. And if we don't have a form for it, what are we going to do? Call your attorney. Well, your buyer, seller's attorney. Questions on seller representations? Then we have, yeah.
So, what if you're about the deed's about to get listed, or recorded? Do you have all the way until the deed is recorded to, kind of like, so say you find something wrong in the house. It's all the way up until that deed's recorded that you can like mention something or say something, right?
The contract says settlement. You sign it, settlement, acknowledging. So when you go to the attorney's office and sit down and they say, sign your life away, part of what you're signing as a buyer is I accept the property in its condition right now.
Okay.
So that's why we just said, if you don't like it, don't go to settlement.
Perfect. Well, I just meant like, say like, if it was a situation where somebody broadcast the house one way and then right before you left, like all of a sudden then you find out there's some major plumbing issues or there's like some hole in the floor. That's what I was getting at. That just popped in my head.
Buyer's got choices. Yep. And it's not an easy choice, is it?
So that would be settlement then.
Anything discovered? Yep.
So then
Settlement.
after the settlement, you can't back out.
That's right.
I'm just curious. Just
Yep.
double check.
Yep. That's what makes, I think that's, Joseph, to your point, I think that's kind of what makes our job really important. Because when you're buying a house, I mean, let's think about some of the price tags on a house, right? This isn't buying a sweater or a pair of jeans or something, is it? I mean, we're talking big price tag. And one thing buyers need to understand is there are no takebacks. There are no returns. You don't have a 60-day window. I mean, when it's a done deal, when that deed is recorded, it is a done deal and buyer and seller are done. Now, could you hire an attorney, go after sell after the fact? Yeah. How far are you going to get? I don't know. It's a case by case. Talk to your attorney. Another question comes in, who keeps all these forms? We have them at the firm. We have access to them. Remember whose documents these are. These are the firms. Firm's forms. You try saying that. These are the firm's forms. So yes, they will have all of their forms. Most firms are using some kind of electronic management system such as Dotloop, DocuSign, something like that. Agents are encouraged to keep their own copies for your own records. But yes, here I go again, the firm's forms. Now I got seller obligations. These are the things that the seller is required to do. Their biggest obligation, to provide that clear marketable title, to make sure all the liens and the defects and the encumbrances, all that has been addressed. The seller's big responsibility is to provide clear marketable title. During due diligence, the attorney is going to do that very thorough search of the title. And if they find any issues related to the title, the attorney will get with the seller to clear that up. So the buyer hires the attorney, which means through the eyes of the attorney, the buyer is their client. And as their client, their number one obligation is to hand their client clear marketable title. So if they find issues, if they find something, the attorney will work with the seller to address it and take care of it. There's that authorization to disclose. Again, everybody needs a copy of it, so the seller's agreeing. Access to property. Seller shall provide reasonable access to the property through the earlier of closing or possession, whichever happens first, including allowing the buyer to conduct their due diligence. So we can't go under contract and then the seller not let a home inspector in. The seller can't deny the appraiser from coming in and doing their job. So even though we're under contract, the seller still needs to let the buyer in so they can do their due diligence. The buyer has the right to verify the satisfactory completion of any negotiated repairs. So if the seller does agree to do repairs, the buyer has the right to make sure that they're completed satisfactorily. And the seller has to allow the buyer the right to conduct their final walkthrough. So the buyer has access to the property, once reasonable access to the property once we go under contract. Removal of seller's property. They're going to remove all personal property, which is not part of the purchase, including all garbage and debris. The buyer doesn't want your junk. Indemnification. Let's see. Payoff of liens, satisfaction of liens. They have outstanding liens. Good title, legal access. We actually saw this paragraph back in Unit 5. Seller's going to execute and deliver a general warranty deed in recordable form no later than settlement, which conveys fee simple, marketable, and assurable title. Without mechanics liens, lis pendens, liens and judgments, encumbrances, a whole bunch of words we learned in the first couple units. Survey, ad valorem taxes, easement, other liens, other encumbrances. It's pretty much the first 5 units of this, of this class is wrapped up in that paragraph. So this again is the seller's big responsibility to provide that good title and legal access. Governmental compliance, you're not going to find this in your book. You're not going to find this in the syllabus because this was what was just added on July 1st. This was the big update to the contract on July 1st. Are you going to be tested on it? I don't know because they haven't updated the syllabus since they have updated the forms. So it's here. I highlighted it. The syllabus didn't highlight it. I highlighted it. Everybody good with me so far? Because I don't know if it's a testable topic, but what I do know is everything else in the contract is highlighted. So I went ahead and added this new as well. So this thing is about 27 days old. And really what this is saying is if the seller knows of any permitting issues, for example, maybe they finished the unfinished basement without a permit, the seller has disclosed such specific violations. So if the seller knows of anything that could materially affect the property due to governmental compliance, the seller is encouraged to disclose. They still don't have to. They're encouraged to disclose. If they don't disclose and a violation is discovered prior to closing, the seller is given the option to cure the violation. If the seller does not cure the violation, now the buyer has choices. They can either choose to accept the violations and go on to settlement, or they terminate and get their earnest money and their due diligence back. Brand new paragraph. My agent saw it for the first time yesterday. You guys are seeing it for the first time today.
I like that paragraph.
You like it?
Yeah.
A lot of us are nervous, George. We think this leaves a lot of room for interpretation. So when in doubt, call your attorney. They said there's a forms committee, and they said with this paragraph, it was meant to give the buyer a leg to stand on if any of this happens. But also it's kind of used, it allows us to start conversations. They also added this paragraph to the listing agreement. So listing agents can have this conversation with sellers before we get to the contract. The buyer can't terminate if the seller discloses. So it's twofold. Seller discloses, the buyer accepts it or don't. If the seller doesn't disclose and the buyer finds it, the seller chooses not to cure it. Now the buyer has a choice. Buy the property with the violations or terminate and get your earnest money and due diligence back. But if the seller discloses, we're done. Everybody with me? The buyer doesn't have an out. All the seller has to do is disclose. So again, I still can't make them disclose, but I can recommend that they disclose because we don't want to give our buyer out. Let's see, Joy, and then I got another question in the chat. Y'all be easy on me. I just saw this for the first time like 2 weeks ago. So it's almost as new to me as it is to you, right? Okay, Joy.
I was gonna say, but the fact that the seller didn't pull or didn't get the required documents that's not it doesn't affect the process of closing or settlement. Like it's not an encumbrance or anything like that that affects title.
They're just disclosing that they
Okay.
didn't have permits or they have other kind of government regulations or ordinances.
So it's really just a preference then.
Could
Kind of.
be, or it could be some kind of governmental compliance or non-compliance.
Got it. Okay.
Yep. Vaughn, that's a great question for non-pre-license and getting off topic a little bit. So I'm happy to address that. But yeah, we can, absolutely.
So is it kind of like a setup to if there's some governmental non-compliance going on and they sell it, like if I'm the buyer and I can't get out of it, like, is that really fair to me though?
Well, if the seller has disclosed, there is no out for the buyer. That's the seller's, if they choose to disclose. So all the seller has to say is, I finished the basement without permits. The buyer can either move on or proceed and terminate the transaction. You with me? They can choose.
Oh, so you
whether or
can
not-
terminate the transaction at that point? Is
during
that
due
what you-
diligence for any reason.
Okay, good. Cause I thought
Yep.
you were saying like, there's no out at that point. Okay. got it.
During due diligence. So if the seller doesn't disclose and then we go under contract and the buyer finds something and the seller and they choose not to, no, where is it? They choose not to cure the violation. They may cure the violation. And if the seller doesn't cure the violation, now the buyer has choices. But if
Okay,
the seller discloses up front, that's it. You either accept this property with this violation
right.
or you don't.
Okay, I got it
Yep,
now. Okay.
Yep. Guys, goodness, did anybody else's stomach just grumble because it's lunchtime? Okay. So this is where we are today. I'm 101 and I know I'm over. Please bear with me for just 1 or 2 more minutes. I promise I'll make up to you next week. I'll let you go a couple minutes early next week. Is that fair? Okay. So what's next week going to look like? We're going to finish unit 10. Pretty much once we get through the contract, we're through the beef of unit 10, but I do encourage you guys to look ahead, page 296 and on. Also next week, once we get through unit 10, we'll talk about your midterm, how that's going to look. We're also going to talk about that process of getting your license. So after unit 10, we're going to kind of take a little bit of a break from the material and focus on what to do next and get you going through that midterm. Once we do that, then we start on our finance units. Please write this down. Our financing units are units 14 and 15. So after unit 10, we go to units 14 and 15. Please look ahead at the financing units. We're going to take a break from thinking like a real estate agent, and we're going to spend a couple units thinking like a lender. Units 14 and 15 introduce us to lender verbiage, lender speak. We're going to have to put a lender's hat on. So I encourage you guys to look ahead to make the financing units easier for us to get through. You expose yourself to it over this weekend, and then we'll talk about it next week. So that's where we are next week. Thank you guys for your patience and your time. I hope you all have a great weekend, and I will see you bright and early Tuesday morning. Thank you. Let's see.